Instead, he follows the law as best he can wherever it might lead, end quote. Well, Mr. President, I could go on. The voices raised in support of Judge Gorsuch are numerous. Well, unfortunately, no amount of testimony in favor of Judge Gorsuch seems to be enough for Democrats. Senate Democrats are apparently determined to oppose Judge Gorsuch, despite the fact that they're struggling to find any good reason to justify their opposition. Senate Minority Leader came down to the floor on March the 23rd to announce his determination to vote against Judge Gorsuch, and he urged his colleagues to do the same. Why? Well, apparently, the Senate Minority Leader is not convinced that Judge Gorsuch, quote, would be a mainstream justice who could rule free from the biases of politics and ideology, end quote. That's right, Mr. President. Despite the fact that everyone, liberal and conservative, seems to describe fairness as one of Judge Gorsuch's distinguishing characteristics, the Senate Minority Leader is not convinced that the judge will be able to rule without bias. He's worried that Judge Gorsuch won't be a mainstream judge. Well, Mr. President, over the course of 2,700 cases on the 10th Circuit, Judge Gorsuch has been in the majority 99% of the time. 99%. In 97% of those 2,700 cases, the opinions were unanimous. I'd like the Minority Leader to explain how exactly a judge who was in the majority 99% of the time is out of the judicial mainstream. Is the Minority Leader trying to suggest that all the judges on the 10th Circuit, including the ones appointed by Democrats, which I might add is a majority on the circuit, are extremists? Mr. President, the fact is Democrat opposition to Judge Gorsuch has nothing to do with his qualifications. Let's just get it out there. I doubt that any of my colleagues on the other side of the aisle really think that Judge Gorsuch is out of the mainstream or that he lacks the qualifications of a Supreme Court justice. No, the truth is that Democrats are opposing Judge Gorsuch because they're mad that it's not a Democrat president making the nomination. Can't accept that they lost the election, so they're going to oppose any nominee, no matter how qualified. Mr. President, it's extremely disappointing that Democrats plan to upend a nearly 230-year tradition of approving Supreme Court nominees by a simple majority vote simply because they can't accept the results of an election. Democrats have no plausible reason to offer for opposing the supremely qualified nominee. I hope that a sufficient number of Senate Democrats will think better of their opposition and vote when we have that opportunity later this week, Mr. President, to confirm Judge Gorsuch to the Supreme Court. Mr. President, I yield the floor.
Mr. President.
Senator from Louisiana.
Thank you, Mr. President. There are, of course, Mr. President, two issues before the Senate with respect to Judge Neil Gorsuch. The first issue is simply, should or should not Neil Gorsuch be confirmed as an Associate Justice to the United States Supreme Court? But there's also a second issue. And the second issue is, should the Senate even be allowed to vote? Those two questions are both important and they're interrelated. I want to talk about the first one first. I sit on the Judiciary Committee, Mr. Chairman. We heard last week, 2 weeks ago, about 20 hours of testimony from Judge Gorsuch. I think he answered about 200 questions in writing. One of the objections offered by our friends on the other side of the aisle, the Democratic Party, is that Judge Gorsuch refused to answer some of the questions. Now, that's just not accurate. Many of the questions that were asked of the judge, both by Democrats and Republicans, were fair questions. Some of them, not so much, Mr. President. Judge Gorsuch was asked, in effect, what's your position on abortion? How will you vote? He was asked, how will you vote on gun control? He was asked, how would you vote on cruel and unusual punishment? The Eighth Amendment. He was asked how he would vote on questions dealing with the 10th Amendment. And he didn't answer those questions. And then he was criticized for not answering those questions. He didn't answer those questions, Mr. President, because he couldn't. He's a sitting judge of the United States Court of Appeals for the 10th Circuit. Let me read to you, Mr. President, Canon 3A6 of the Code of Conduct for United States Judges. It states, quote, a judge should not make public comment on the merits of a matter pending or impending in any court. End quote. Let me read you, Mr. President, Rule 2.10b of the American Bar Association Model Code of Judicial Conduct. It provides, and I quote, Mr. President, a judge shall not, in connection with cases, controversies, or issues that are likely to come before the court, make pledges, make promises, or make commitments that are inconsistent with the impartial performance of the adjudicative duties of the judicial office. Now, say what you want about Judge Gorsuch, but don't criticize him for not violating the oath of his office and not making promises or pledges or commitments like a politician on how he would vote on the United States Supreme Court, because justices are supposed to decide the case on the merits. Now, as I mentioned, Mr. President, I watched Judge Gorsuch answer questions personally for over 20 hours. And he was asked some other questions other than the ones I've referenced. And I was intrigued by some of the questions that Judge Gorsuch was asked. My friends in the Democratic Party kept trying to draw distinctions with Judge Gorsuch between the parties in cases that he had decided. My friends kept talking about the big guy, the little guy, the corporation, the consumer, the employer, the employee, and the suggestion was made that Judge Gorsuch, he didn't vote enough for the little guy or the little gal, or whatever that means. And what struck me when he was asked these questions is that what we were supposed to be talking about, Mr. President, was the faithful application of justice. Now, I was taught in law school that justice, Lady Justice, is supposed to be blind, that neither the wealth nor the power nor the status of the parties should matter. That's why the picture that we see so often of Lady Justice, she's blindfolded. She isn't looking at the parties at all to see whether they're wealthy or not so wealthy. She isn't looking at the parties to see whether they're a corporation or a consumer, or what race they are, or what gender they are, or what part of the country they're from. Lady Justice is supposed to be blind, because we're a nation of laws, not men. And of all places in our country, an American court of law, and I'm very proud of this, is supposed to be the place of last resort where you can come and get a fair shake. And that's how good judges operate. They give everybody a fair shake. A good judge is supposed to make his or her decisions based on the law, not the parties. Good judges are supposed to be impartial, to call it like they see it, to call the balls and strikes, and that's exactly what Neil Gorsuch has done throughout his entire career. And I promise you, Mr. President, I sit on the Judiciary Committee. And if any president, whether he is a Republican or a Democrat, ever brings a nomination before Judiciary Committee when I'm on that committee, and that nominee starts talking about the wealth or the status or the power of the parties and how it will influence or not influence his decisions, suggesting that that will make a difference, I will vote against that nominee. I don't care who nominates him every single time, because that's not American justice. Mr. President, we talked about two cases in particular, and you've probably heard them talked about here on the floor. And on the surface, they don't seem to be related. Judge Gorsuch ruled in both of these cases, but I think they interact in a very important way, and they tell us a lot about the man. They tell us that he doesn't play politics. He doesn't rule for the big guy just because he's a big guy, or the little guy just because he's a little guy. The first case we heard a lot about was a decision by Judge Gorsuch in a case called Trans Am Trucking. You're going to hear a lot about that case. Now, in that case, Judge Gorsuch made a decision that was unfavorable to a trucker, and he ruled in favor of the trucking company. Little guy versus big guy. And Judge Gorsuch ruled for the big guy. But it's important, Mr. President, to know why. To look at the reasoning in that case and not just the result. During the discussion on the case, Judge Gorsuch made it very clear that he only made that decision because he believed that that was what the statute controlling the facts of the case required. A statute that was passed by a legislative body, duly authorized by the people to make the law, unlike our courts, which are supposed to interpret the law. Judge Gorsuch did not decide that case the way he did because he didn't sympathize with the trucker. He decided that case the way he did because he was doing his best to accurately apply the law as best he understood it to the facts before him. Once again, that's what's called justice, blind to the parties. And actually, Judge Gorsuch explained himself what he thinks about decisions like this. He did it in another case that I will talk about in a moment. Let me read his direct quote. This is what Judge Gorsuch said. Quote, often the law can be an ass, an idiot. Quoting, of course, Charles Dickens. And there is little we judges can do about it. For it is or should be emphatically our job to apply, not rewrite the law enacted by the people's representatives. Indeed, a judge who likes every result he reaches is very likely a bad judge, reaching for results he prefers rather than those the law compels. Now, that statement, Mr. President, came from the second case I referenced. It was a case called A.M. Holmes. In A.M. Holmes, a 13-year-old seventh grader was arrested for fake burping repeatedly in class. Now, the majority said it was okay for him to be arrested, and that when his family sued the police officer enjoyed qualified immunity. Judge Gorsuch dissented. This time he ruled for the little guy, literally and figuratively. Judge Gorsuch said, in my opinion, reading the statutes passed by the legislature, this young man's family can file this lawsuit because disciplining a 13-year-old seventh grader for fake burping in class by arresting him instead of disciplining him is a bridge too far. Now, once again, we had a little guy versus a big guy. This time, Judge Gorsuch ruled for the little guy. But again, we have to look at beyond the result, Mr. President. Even though he ruled for someone we can all sympathize with, Judge Gorsuch didn't base his decision on that. He based it on a good faith application of the statutes controlling the facts of the case. He applied the law as written by the legislature. That's what legislatures do, Mr. President. That's what Congresses do. They make law, and judges interpret the law. And to be blunt, Mr. President, that's what we want in a judge. I want a judge. I don't want an ideologue. I'm not interested in a judge who will use the judiciary to advance his own personal policy goals. I want a judge, Mr. President, who will apply the law as written by the legislature, or in the case of the Constitution, as written by the framers of the Constitution, as best that judge understands the law, not to try to reshape the law as he wishes it to be. Mr. President, just a comment about the last question that I raised earlier. Again, one issue is whether or not we should confirm Judge Gorsuch to the Supreme Court. But the second issue is whether the Senate should even be allowed to vote at all. And that's what this is all about when you distill it down to its basic essence. We're going to hear a lot about cloture, and we're going to hear a lot about the nuclear option. But this is what it boils down to. Should we or should we not even be able to allow to vote? Now, I understand that reasonable people can disagree. I also understand that unreasonable people can disagree. And everybody in this body has a vote. And we all represent states. There are 2 senators from every state, big states and little states. And everybody is entitled to be able to vote his or her conscience. But it is very, very important, not only for the American judicial system, but for American democracy, that the United States Senate be allowed to vote on Judge Gorsuch. And so, to my friends on the other side of the aisle, I would say, please allow us to vote. Please, you can vote for or against Judge Gorsuch. I won't second guess your judgment if you act sincerely, and I believe many of my colleagues are sincere. They're wrong, but they're sincere. But please allow the United States Senate to vote on this nomination. That's why I was sent to Washington, Mr. President. I yield the floor.
Mr. President.
Senator from Arkansas.
This week, the Senate will fulfill one of our most important responsibilities, advice and consent for a nominee to the Supreme Court. The stakes don't get much higher than a lifetime appointment to a court of final appeal, especially as the court is presumed over the last 2 generations to take more and more political and moral questions out of the hands of the people. President Trump has nominated Judge Neil Gorsuch, a distinguished jurist who understands the critical but limited role of the federal courts in our constitutional system. To my knowledge, no senator genuinely disputes his eminent qualifications, his judicial temperament, and his outstanding record over the last decade on the 10th Circuit Court of Appeals. Indeed, Judge Gorsuch would appear headed toward an easy, non-controversial confirmation based on the comments by Democratic senators. The senior senator from Colorado introduced Judge Gorsuch at his confirmation hearings with this high praise: "I have no doubt that Judge Gorsuch has profound respect for an independent judiciary and the vital role it plays as a check on the executive and legislative branches. I may not always agree with his rulings, but I believe Judge Gorsuch is unquestionably committed to the rule of law." The senior senator from Indiana recently announced his support for Judge Gorsuch, saying, "I believe he is a qualified jurist who will base his decisions on his understanding of the law and is well respected among his peers." The senior senator from West Virginia has noted Judge Gorsuch has been consistently rated as a well-qualified jurist, the highest rating a jurist can receive, and I have found him to be an honest and thoughtful man. The junior senator from North Dakota also praised Judge Gorsuch for his record as a balanced, meticulous, and well-respected jurist who understands the rule of law. Remember, these admiring statements all come from Democrats, and all of them support an up or down vote on confirming Judge Gorsuch. Even those who oppose Judge Gorsuch used to sing a different tune about the standards for judicial confirmation. For instance, the senior senator from California put it best when she said, "I think when it comes to filibustering a Supreme Court appointment, you really have to have something out there, whether it's gross moral turpitude, or something else that comes to the surface." Speaking of a previous Republican president's nominee, she further said, "Now, I mean, this is a man I might disagree with. That doesn't mean he shouldn't be on the court." In fact, President Obama filibustered a Supreme Court nomination while he was a senator, yet later expressed regret over that decision. He said, "I think that historically, if you look at it, regardless of what votes particular senators have taken, there's been a basic consensus, a basic understanding that the Supreme Court is different. And each caucus may decide who's going to vote where and what, but that basically you let the vote come up and you make sure that a well-qualified candidate is able to join the bench, even if you don't particularly agree with them." Despite all this, though, it appears a radical Democratic minority intends to filibuster Judge Gorsuch's nomination. And the minority leader is encouraging this extreme fringe, claiming if Judge Gorsuch fails to earn 60 votes and fails to demonstrate he is mainstream enough to sit on the highest court, we should change the nominee and not the rules. I will return later to the minority leader's central and ironic role in all of this. But for now, let's take a trip down memory lane to understand just how radical this partisan filibuster would be. No Supreme Court nominee has ever failed because of a partisan filibuster. Never, not once, ever, in the 228 years of our venerable Constitution. One nominee, Justice Abe Fortas, to be elevated to Chief Justice, lost one cloture vote in 1968 on a bipartisan basis and then withdrew under an ethical cloud. But no Supreme Court nominee has ever been defeated by a partisan filibuster. And this historical standard has nothing to do with changes in the Senate rules. The filibuster has been permitted under Senate rules since early in the 19th century. It's not a recent or a novel power. The cloture rule was adopted 100 years ago. In other words, at any point in our history, a Senate minority could have attempted to filibuster a Supreme Court nominee. They had the tools. The rules permitted it. It would have only taken one senator, just one. Yet it never happened for a simple reason: self-restraint. While written rules are important, sometimes the unwritten rules are even more so. Habits, customs, mores, standards, traditions, practices, these are the things that make the world go round. In the United States Senate, no less than in the game of life. Our form of self-government depends critically on this form of self-government. Let's reconsider some recent nominees in light of these facts. Justice Clarence Thomas was probably the most controversial nomination in my lifetime. perhaps ever. He was the subject of a vicious campaign of lies and partisan smears, a high-tech lynching, in his words. He was confirmed in 1991 by a bare majority of 52 to 48. Yet Justice Thomas did not face a filibuster. Not a single senator tried to block an up or down vote on his nomination. Not Joe Biden, not Ted Kennedy, not Robert Byrd, not John Kerry, not one. Why? Any one senator could have demanded a cloture vote, could have insisted upon the so-called 60-vote standard, and perhaps defeated Justice Thomas's nomination. But they didn't, because they respected 2 centuries of Senate tradition and custom. Likewise with Justice Sam Alito, whose nomination unquestionably shifted the court's balance to the right in 2006. He too received fewer than 60 votes for confirmation, 58 to be exact. But he received 72 votes for cloture. Here again, a large bipartisan majority upheld the Senate tradition and custom against partisan filibusters of Supreme Court nominees. Even Judge Robert Bork, whose name is now used as a verb to mean unfair partisan treatment of a judicial nominee, received an up or down vote in 1987. Yes, Judge Bork, who only received 42 votes for confirmation, didn't face a partisan filibuster. But let's not stop with Supreme Court nominations. Let's also consider other kinds of nominations so we can understand just how radical is the Democratic minority's position. To this day, there has never been a cabinet nominee defeated by a partisan filibuster. Never, not once, ever in 228 years of Senate history. And to this day, there has never been a trial court nominee defeated by a partisan filibuster. Never, not once, ever in 228 years of Senate history. And until 2003, just 14 years ago, there had never been an appellate court nominee defeated by a partisan filibuster. That's just how strong the custom against filibusters was. It had never successfully happened in 214 years. From our founding, through secession and Civil War, through world wars, no matter how intense the feeling and how momentous the occasion, no matter how partisan the atmosphere, senators always exercised self-restraint and allowed up or down votes on nominees to the Supreme Court, the Court of Appeals, the trial court, and the cabinet. But that changed in 2003, thanks in no small part to the senior senator from New York, Chuck Schumer, now the minority leader. With the help of left-wing law professors, he convinced extremists in the Democratic caucus to filibuster President Bush's appellate court nominees. So, for the first time in more than 2 centuries of the United States Senate, a radical minority defeated nominations with a partisan filibuster. Why did the Senate start down this path? Some point to racial politics and Miguel Estrada, one of the most talented appellate litigators of his generation and President Bush's nominee to the D.C. Circuit. That court is often a proving ground for future Supreme Court nominees. And Mr. Estrada's confirmation might have enabled President Bush to nominate him subsequently to the Supreme Court. A Republican president appointing the first Hispanic justice? Well, surely the Democrats couldn't allow that. But whatever the reason, there can be no doubt that the minority leader set in motion a chain of events over the last 14 years and brought us to the point he claims to deplore today. So the Democrats can spare me any hand-wringing about Senate traditions and customs. The minority leader and like-minded extremists in the Democratic caucus can also spare us their exaggerated claims of Republican obstruction of President Obama's judicial nominees. The Democrats, after all, were the ones who broke a 214-year-old tradition, specifically to obstruct 10 of President Bush's nominees. Of course, the Republicans followed suit, though I'd note they filibustered fewer judges over more years spent in the minority. Put simply, the Democrats broke one of the Senate's oldest customs in 2003 so they could filibuster Republican judges. And they subsequently filibustered more judges than did the Republicans. So it should come as no surprise that the Democrats took an even more radical step in 2013 when they used the so-called nuclear option to eliminate the filibuster for executive branch, trial court, and appellate court nominations. They broke the Senate rules by changing the Senate rules with a bare majority, not the effective two-thirds vote required under those rules. The radical Democrats will accept no constraints on their will to power when in power, whatever it takes to pack the courts with liberal extremists or block eminently qualified Republican nominees is exactly what they'll do. But don't take my word for it. Let's review what the Democrats were saying last year when they all believed they'd be in power with Hillary Clinton as president and Democrats controlling the Senate. We didn't hear much talk about the sacred 60-vote standard back then. On the contrary, the Democrats were promising to use the nuclear option again, this time to confirm a Democratic nominee to the Supreme Court. Former Senate Minority Leader Harry Reid said, "I have set the Senate so when I leave, we're going to be able to get judges done with a majority. If the Republicans try to filibuster another circuit court judge, but especially a Supreme Court justice, I've told them how, and I've done it in changing the rules of the Senate." The junior senator from Virginia, who would have been vice president had Secretary Clinton won, said quite frankly about the Supreme Court vacancy, "If these guys think they are going to stonewall the filling of that vacancy or other vacancies, then the Democratic Senate majority will say, we're not going to let you thwart the law." The junior senator from Oregon warned ominously, "If there's deep abuse, we're going to have to consider rule changes." And the senior senator from New Mexico perhaps summed it up best of all when he said, "The Constitution does not give me the right to block a qualified nominee, no matter who is in the White House. A minority in the Senate should not be able to block qualified nominees." Don't think for a minute that the radical Democrats would not have made good on these threats. They've exercised little restraint on judicial nominations over the last 14 years. They betrayed over 200 years of Senate tradition and custom. They wouldn't start respecting those traditions now. In reality, there were good reasons to respect and uphold the old Senate tradition against filibusters of nominees before 2003. First, our responsibility under the Constitution is not to choose, but to advise and consent. A partisan filibuster would essentially encroach upon the president's power to nominate the person of his choice. Second, nominations aren't susceptible to negotiation. We can't split someone down the middle, Solomon-like. We can vote yes or no. This isn't the case with legislation, where differences can be split, compromises negotiated, bipartisan consensus reached. Third, when legislation fails to win 60 votes, it's not the end of the world. It can go back to the drawing board or be enacted through other legislative vehicles. But when nominations are long delayed or defeated, then real work is left undone. Cases go unheard. Disputes go unresolved. The law remains unclear. It would have been better for the Senate if the minority leader and the Democrats had recognized these things in 2003 and not started us down this path, the end of which we reach this week. It's rarely a good thing when an institution ignores or breaks its customs and traditions, its unwritten rules. They should have known better, and they should have acted better. But we've come to this point because the radical Democrats didn't act any better. Now, they propose to create a new standard, never known to exist before, The Senate will not confirm a Republican president's nominees to the Supreme Court, because if the Democrats will filibuster Neil Gorsuch, then they will filibuster any Republican nominee. I will never accept this double standard, and neither will my colleagues. Republicans aren't going to be played for suckers and chumps. After this week, the Senate will be back to where it always was and where it should have remained. Nominees brought to the floor ought to receive an up or down, simple majority vote. And don't expect to hear regret from me about it. There's no moral equivalence here between the two parties. To suggest any equivalence is to divorce action from its intent and aim. In 2003 and again at this moment, the radical Democrats overturn venerable Senate traditions. The Republicans are acting to restore them. Those who cannot see the difference, to borrow from Bill Buckley, would also see no difference between a man who pushes an old lady into the path of an oncoming bus and a man who pushes the old lady out of the path of the bus, because, after all, both men push around old ladies. So I'm not regretful. I'm not racked with guilt. I'm not anguished. I'm really not even disappointed. There are no schoolyard taunts of "you did it first." There are no charges of hypocrisy. There's no pox on both our houses. The Republicans are prepared to use a tool the Democrats first abused in 2013 to restore a 214-year-old tradition the Democrats first broke in 2003. And we're supposed to feel guilty? Please. The radical Democrats brought this all on themselves and on the Senate. The responsibility rests solely and squarely on their shoulders. The minority leader is hoist with his own petard. The Senate is restored to a sensible, centuries-old tradition. And Judge Gorsuch is about to become Justice Gorsuch. Not a bad outcome. Not bad at all. Pretty good, in fact. Mr. President, I yield the floor.
Mr. President.
Senator from Texas.
Mr. President, I come to the floor today to support the confirmation of Neil Gorsuch to serve as an Associate Justice on the Supreme Court of the United States. By any objective measure, Judge Gorsuch is impeccably qualified. He is a graduate of Columbia University and the Harvard Law School and was awarded a doctorate from Oxford. He is a former law clerk to the legendary Justice Byron White, as well as for Justice Kennedy. And he has been a respected federal appellate judge for a decade. Judge Gorsuch has spent a lifetime in the law, and his record indicates that he will make an exemplary justice. Just 2 weeks ago, Judge Gorsuch testified for 20 hours before the Senate Judiciary Committee. His conduct during the hearing only further confirmed what his record demonstrates: that Neil Gorsuch is a principled jurist and a good man. And I was glad for all of us to get that confirmation, because Judge Gorsuch bears a heavy responsibility. He is being asked to fill the seat of Justice Antonin Scalia. In truth, I doubt that anyone could truly fill Justice Scalia's shoes. Justice Scalia was one of a kind, and his enormous impact on the law and on the court will impact this nation for generations to come. All of us miss him dearly. But I take solace in the knowledge that one of the ways in which I believe it will be easiest for Judge Gorsuch to imitate Scalia, perhaps the most important way, is judicial humility. Justice Scalia's greatest strength was not his amazing wit, his mighty pen, or his larger-than-life personality, as much as we loved those parts of him. Rather, it was his consistent unwillingness to accumulate power to himself and to the courts. He refused to impose his own personal policy preferences on the law, but instead understood that his role as a judge was simply to apply the law that the elected representatives of the people had enacted. This type of judging doesn't take otherworldly talent, though Scalia had that in abundance. Instead, it takes character, integrity, humility. Judge Gorsuch's lengthy record and his hearing testimony demonstrate that he has those attributes as well. He understands that his role as a judge is to apply the words of the Constitution and the laws of the United States to the specific cases that come before him, and nothing more. This is critical in an era when the Supreme Court has come to be seen by many, for good reason, as an activist court, as a super legislature that seeks to impose its own will in the place of the written law. It is this very humility that angers so many on the left. They don't want someone who humbly applies the law. Rather, they demand nothing less than a person fully committed to enacting from the Supreme Court bench whatever policies the left is championing at that given moment, because they know that their only refuge is the courts, because the American people would reject the policies at the voting booth. Judge Gorsuch is clearly not that kind of person, so they have committed to opposing his confirmation by whatever means necessary, legitimate or not. Indeed, if this were being decided on qualifications and record, Judge Gorsuch would be confirmed unanimously. And we don't have to hypothesize about that, because Judge Gorsuch has already been confirmed by this body a decade ago by voice vote without recorded dissent. Not a single senator objected. Not Ted Kennedy, not Hillary Clinton, not Barack Obama, not Joe Biden, and not even Democratic members who still serve in this chamber, like Chuck Schumer, Dianne Feinstein, Pat Leahy, or Dick Durbin. Not a one of them spoke out against Gorsuch's nomination to the Court of Appeals. Not one. So what changed? The only thing that changed is that the radical left has become angry, extremely angry. And my Democratic colleagues are worried that they will get opposed from their left in a primary. That's it. Their base demands total war, total obstruction. And they are begrudgingly bowing to this demand. Unfortunately for them, it has proven difficult to invent attacks against an obviously well-qualified judge like Judge Gorsuch. My Democratic colleagues couldn't get any legitimate grievance to stick at the hearings last week, despite their best efforts. But it hasn't stopped them from repeating their outlandish attacks over and over again. If the stakes weren't so high, it might even be humorous. But it isn't really funny, because the primary argument that the Democrats have made is dangerous. Their attack on Neil Gorsuch is a direct attack on the rule of law itself. Contrary to the foundations of our government and legal system, my colleagues from across the aisle are arguing that Judge Gorsuch is unqualified to be a justice because he allegedly failed to side with the, quote, little guy over the big guy. In their view, it is now the job of judges to reject equal protection, to take the blindfold off of Lady Justice. And instead, judges should put their thumbs on the scale to actively discriminate against parties based on their identity. This notion of partisan, results-oriented judging is directly contrary to the constitutional system we have in this country. My Democratic colleagues are openly calling for judges to enforce their own political preferences from the bench, and they want to use a person's willingness or unwillingness to do so as a litmus test for who gets on the court. This isn't even a jurisprudential position. It's a political position. And it's difficult to imagine a more effective way to destroy our judicial system, the best in the world, despite its flaws, than to adopt this results-oriented approach. Make no mistakes, the Democrats' trumpeting of outcome-based judging will have consequences. Judges and potential judges nationwide will now have heard their siren call. You want smooth sailing and a confirmation hearing from the Democrats? Ignore the law, ignore the facts, and pick sides based upon who you sympathize with, whoever is politically correct at that moment in time. My Democratic colleagues claim to detest attacks on the independent judiciary. There aren't many attacks more dangerous and chilling of true independence and impartiality than the one they're making now. The public, the people that appear in court seeking an honest tribunal, have also heard this open call for bias, for prejudice, for discrimination. And I doubt they'll soon forget it. Luckily, Judge Gorsuch stood firm at his confirmation hearing. He reaffirmed what was clear from his record, that he will not legislate his own policy preferences from the bench, and that he will respect the limited role a judge plays in our constitutional structure. He did all of this in the face of unrelenting opposition from my Democratic colleagues, who demanded that he violate his judicial oath and swear to decide certain cases and political questions in a way that they would prefer. No recent nominee to the Supreme Court has ever made such pledges, and Judge Gorsuch rightfully refused to do so last week. Their demands of Judge Gorsuch were particularly galling, given that this was the most transparent process in history for selecting a Supreme Court justice. During the campaign, Donald Trump promised the American people that if elected, he would choose a justice in the mold of Justice Scalia. He laid out a specific list of 21 potential nominees, including Judge Gorsuch. The voters were able to see precisely who President Trump would nominate, and they were able to decide for themselves if that was the future they wanted for the Supreme Court. Hillary Clinton, on the other hand, promised a very different kind of justice. She promised a liberal judicial activist who would vote to undermine free speech, to undermine religious liberty, to undermine the Second Amendment right to keep and bear arms. In a very real sense, this election was a referendum on the Supreme Court. The American people could decide for themselves between a faithful originalist vision of the Constitution and a progressive liberal activist vision. And the voters chose. Donald Trump is now President Trump. And he has kept his promise to the American people, selecting Judge Neil Gorsuch from that list of 21 judges. Judge Gorsuch is no ordinary nominee. Because of this unique and transparent process, unprecedented in our nation's history, his nomination carries with it a kind of super legitimacy in that it has been ratified by the American people at the voting booth. Neil Gorsuch is not simply the president's nominee. It is a direction chosen by the American people, and I urge my colleagues to confirm him. I yield the floor.
President.
Senator from New Jersey.
Thank you, Mr. President. I'm rising today to voice my opposition to the nomination of Judge Neil Gorsuch to be an Associate Justice on the Supreme Court of the United States. The nomination of an individual to serve on the Supreme Court is a matter of tremendous importance. Supreme Court justices have the opportunity to literally shape and even define American history for decades to come. And even more importantly, they have the opportunity to affect the lives and the livelihoods of everyday Americans now and in generations yet unborn. Few decisions in the Senate have a more profound consequence than the confirmation of a nominee for a lifetime seat on the highest court in the land. I recognize this is one of the most critical votes that I will take or any senator will cast. After reviewing Judge Gorsuch's record, I have decided to uphold my constitutional duty of service to advise and consent by opposing Judge Gorsuch's nominee at all stages of the confirmation process, including Senate floor up or down votes for both cloture and confirmation. Now, I didn't come to this decision lightly. I arrived at this conclusion because I believe the next Associate Justice to the Supreme Court must be someone who understands the importance of judicial restraint, someone who will adhere to precedent, someone who will respect and has respect for all the co-equal branches of government, someone who views the Constitution as a living, not static document, someone whose judicial views actually fall within the mainstream of judicial thought and jurisprudence, and someone who has a deep understanding of the law, the Constitution, and its applications. And critically, I believe that the next Supreme Court justice must be someone who understands the gravity of their work, that their decisions will affect livelihoods, will affect lives, will affect the liberties and the rights that we value, not just for those in places of privilege and power, but for all American citizens, for all of the people, now and for decades to come. The American people need the next justice on the nation's highest court to be someone who will protect the rights for all, for everyone, and will ensure that the words literally inscribed above the Supreme Court, equal justice under law, that will ensure that those words are made manifest in everyone's lives. After careful consideration of Judge Gorsuch's record, his judicial philosophy, and after meeting with the nominee and examining remarks and answers to questions in his confirmation hearing, I do not believe Judge Gorsuch meets this high standard, and I cannot support his nomination to be a Supreme Court justice. Judge Gorsuch is truly a well-credentialed jurist. But we must understand that a good resume is the beginning and not the end point of a standard by which we must measure nominees to serve on the Supreme Court. A good resume is necessary, but it is not sufficient to be on the highest court of the land. When it comes to the Supreme Court, the Senate's duty to advise and consent means more than merely measuring an aptitude or an understanding of the law. It means more than just looking at someone's colleges and law schools. It means more than just admiring, does this person have an impressive resume? It necessitates an understanding of it. It actually necessitates an empathy for how these decisions will affect the lives of everyday Americans. Do they have the capacity to stand for all of us? I take literally the Constitution the way it began. It began with the words in the preamble to the Constitution. In many ways, it is a direct point at what's at stake when you nominate an individual to the Supreme Court. It is a critical way that we began. It begins by saying, we the people. The inclusion of these words as the start of one of our nation's founding documents is actually no accident. It was a subject of consternation and even discussion and debate. It's worth noting that the original draft of the preamble of the Constitution of the United States, as prepared by a man named Gouverneur Morris, it had a different beginning. It said, "We, the people of the states of New Hampshire, Massachusetts, Rhode Island," and so forth. But Morris and other drafters of the Constitution made the conclusion and really the conscious decision to remove references to states, to bring it back to the people, that the power of government is derived by the people, that is the fundamental aspect of our society, that we the people, not people of any one state, not people of any one religion, not people of any one race or class, but we the people, all of the people. In a debate about this change, it was actually James Madison who argued that, and I quote, "In this particular respect, the distinction between the existing and the proposed governments is very material. The existing system has been derived from the dependent derivative authority of the legislatures of the states, whereas this is derived from the superior power of the people." It is a deference, it is a reverence for the understanding of the power of the people, all people. It is no accident that this is how our Constitution began, and it's the spirit in our nation that has helped us for centuries to expand upon this ideal of we the people. Understand this. Some of our greatest leaders fought to make sure that these ideals were far vaster, far more inclusive. I note, for instance, Susan B. Anthony, who said, and I quote, "It was we the people, not we the white male citizens, not yet we the male citizens, but we the whole people who formed the Union. And we formed it not to give the blessings of liberty, but to secure them, not to the half of ourselves and to the half of our prosperity, but to the whole people, women and men." You see, this fundamental understanding of our Constitution expanded to be more inclusive, to include women and minorities and religious minorities. This conception of we the people is critical. And it's unfortunate that too often, even with the best intentions, our elected officials, Supreme Court justices, and even presidents have forgotten the precision of these words that were chosen. But despite this, because of heroes like Susan B. Anthony and others, the people of this nation have remembered them, and our nation has grown to be who we are now. And we often actually take for granted the critical role the Supreme Court has played in focusing on the people, on all the people. This has been the power and the majesty of the Supreme Court, this focusing of the individual rights, the dignity, the worth, the value of all people. In the Supreme Court case in Hammer versus Dagenhart, the Supreme Court ruled that Congress has the power to enact labor laws that protect children. They remembered we the people, in this case, the citizens against powerful corporations. In West Coast Hotel versus Parrish, the Supreme Court upheld the constitutional of a state minimum wage law, again, focusing on the people. We the people. In Mapp versus Ohio, when the Supreme Court decided that evidence obtained through the illegal search, the violation of individual privacy, they remembered, again, we the people. In New York Times Company versus Sullivan, when the Supreme Court protected the right of everyday citizens to criticize their government, they remembered that sovereignty, that power, that importance of we the people. In Baker versus Carr, when the Supreme Court established the principle of one person, one vote, they remembered we the people. So many of the rulings during the 50s and 60s governing issues of race in our nation so many of us in our nation owe our very success, the opportunity that was expanded because the Supreme Court, against social mores, against the laws of states, focused on we the people. Perhaps the most famous of those is Brown versus Board of Education, when the Supreme Court asserted that separate but equal had no place in the education of our children. They remembered we the people. In Loving versus Virginia, when the Supreme Court ruled unconstitutional state laws that banned interracial marriage, that ideal of being able to join in union with someone you love, regardless of race, Supreme Court remembered we the people. In Olmstead versus LC, when the Supreme Court reinforced the right of people with developmental disabilities to live in the community and not be institutionalized, they saw a greater inclusion of all Americans. They remembered we the people. I stood on the Supreme Court steps. I sat in the Supreme Court discussions in Obergefell versus Hodges, when the Supreme Court ultimately ruled that state laws cannot stop you from marrying who you love. They remembered, they saw the dignity and the worth of all of the people and ensured that equality. They remembered we the people. In each of these cases, so much was at stake: the rights of workers, the rights of children, the rights of people with disabilities, the rights of minorities, the rights of women, voting rights, civil rights, our rights, American rights. The Supreme Court, with jurists on the right and the left, jurists appointed by Republicans and Democrats, looked to people and affirmed dignity and worth and well-being. But these are not just issues that are done in the past. The Supreme Court is going to be again confronted by historic and deep constitutional cases. There is still so much at stake, and that's why this decision before the Senate is so consequential. Your right to gain access to birth control, your right to criticize your elected officials, your right to marry someone you love, that's still at stake. I cannot vote in support of a nominee who I don't trust to protect American individuals, to understand the expansive nature of that idea of we the people. Judge Gorsuch is someone who, in its own words, has said judges should try to apply the law, I quote, apply the law as it is, focusing backward and not forward. But based on his record and his writing, it is clear to me that Judge Gorsuch's own judicial philosophy leaves out critically important elements of democratic governance. Judge Gorsuch's evasive answers to questions during his confirmation hearing didn't do anything to allay my concerns. We the people, the first words of the Constitution, but these words, I fear, that Judge Gorsuch's record suggests are not his greatest consideration. In fact, at times, when he does his judicial interpretations, they look as if those individuals that make up our society, we the people, are the least of his considerations. Take, for example, Alphonse Maiden, the man who was working through the night in the dead of winter as a truck driver, that his brakes unfortunately froze on him. Knowing the danger of continuing to drive with frozen brakes, danger to himself and other motorists on the road, Alphonse pulled over to the side of the road and called for help. As several of my colleagues have noted in Judge Gorsuch's confirmation hearing on the floor, Alfonso waited for over 2 hours in the freezing cold without heat, experiencing symptoms of hyperthermia. After no help arrived, Alphonse feared for his life and ultimately finally left his trailer to find help. Less than a week after this incident, Alphonse was fined for abandoning his trailer. He filed complaint with the Department of Labor, and the case was brought before the 10th Court Circuit of Appeals, where all but one of the judges ruled in favor of Alphonse, a guy who took a practical decision, an urgent decision to save his own life and not risk the lives of others. But the judge who ruled against this individual in favor of the corporation was Judge Neil Gorsuch. He chose to save his own life and protect the lives of others who would have been put in harm's way if he chose another option, and he was fined for it. Every judge on the 10th Circuit supported that decision except for Judge Gorsuch. We the people includes Luke, a student with a disability. He was diagnosed with autism at the age of 2. When Luke entered kindergarten, he began receiving specialized educational services from his school district as insured by the Individuals with Disability Act, or the IDEA. A law Congress debated and passed with Republicans and Democrats that says children with disabilities are entitled to receive a free and appropriate public education. Between kindergarten and the 2nd grade, Luke achieved many of the goals of his individualized education program. But when Luke's family moved to Colorado and he enrolled in a new public school, he had trouble adjusting, and Luke regressed in areas that he had previously done well in. To better suit Luke's needs, Luke's parents, who tried to get him better care, eventually withdrew from his local school and enrolled him in a private residential school for children with autism. His parents sought reimbursement for the cost of that private school, but the public school district refused to pay. By the time Luke's case reached the 10th Circuit, a federal judge and 2 administrative courts had agreed that the school district should pay because Luke did not receive the free and appropriate education he was entitled to. The question for Judge Gorsuch was, what constitutes an appropriate education? In that ruling, Judge Gorsuch wrote the opinion saying that the educational benefit mandated by IDEA must merely be more than de minimis. More than de minimis. That was the standard that he set for one of our American children. Because the school district gave Luke a de minimis education, Judge Gorsuch ruled that Luke's parents were not entitled to reimbursement. But just last week, the Supreme Court unanimously rejected Judge Gorsuch's merely more than de minimis standard. Unanimously rejected Judge Gorsuch's standard as contrary to the intent of Congress. In fact, at the very moment when Judge Gorsuch testified before the Judiciary Committee, Chief Judge Roberts wrote an opinion rejecting Gorsuch's IDEA standard, saying, when all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to have been offered an education at all. Judge Gorsuch's misinterpretation of the law depriving a child with a disability of the education he deserves should be cause for concern to any of my colleagues as they are promoting him to the highest court in the land. It is this idea of who is important. Powerful institutions, or often the powerless who fight against these corporations or big institutions and turn to the court system as their avenue to get the equal justice under the law, that will view them, whether it's a corporation, whether it's a government, will view them as an equal under the law and give them their right to be heard. This is what we the people is. It means people like Alphonse Madden and Luke, who Judge Gorsuch ruled against. And it also means female workers who want access to contraceptive coverage, but were denied that by their employer, denied by a corporation. Judge Gorsuch ruled against the people and for the corporation. We the people means those millions of Americans who rely on Planned Parenthood centers for health care. Judge Gorsuch ruled against those people seeking what in some counties is their only access to contraceptive care. We the people means the people harmed by medical device manufacturers urging unsafe off-label usages. Judge Gorsuch ruled against the people injured and for the manufacturers, for the corporation. We the people means that a worker fatally electrocuted while on the job due to inadequate training, whose families sought justice. Judge Gorsuch ruled against the individual and for the corporation. We the people means the woman prevented from suing for sexual harassment, not because the sexual harassment didn't exist, but because she didn't report it quickly enough. Judge Gorsuch supported the corporation against the woman. We the people means that a transgender woman who is denied access to a bathroom at work. Judge Gorsuch ruled against the individual in favor of the corporation. We the people means that every single American deserves to have their rights, deserves to have their civil rights, deserves to have their equality protected by the judicial branch, which is often their last avenue towards justice. It's often their last hope against the powerful, against the wealthy. But Judge Gorsuch's record in everything from workers' rights to women's rights to civil rights to the rights of children with disabilities to the rights of a guy on the side of a highway to save his own life suggests that he has forgotten perhaps the most important element of the Constitution, that it exists to protect and serve the American people, not corporations, not lobbyists, not those rich enough to hire fancy big law firms. It doesn't exist to serve a political ideology. It exists to serve we the people. I am not confident in Judge Gorsuch's ability as a Supreme Court justice to safeguard the rights and liberties of all Americans, to prioritize judicial restraint over judicial ideology, to ensure equal justice under the law, and to understand and act in a way that indicates that real people's lives who are struggling against often seemingly insurmountable odds, that for them everything is on the line. I'm not sure that Judge Gorsuch on the Supreme Court can honor this tradition. We the people means an independent judiciary that will not close the courthouse doors on people, on our civil rights. That won't look at litigants as just pawns in a larger ideological contest of ideas, but will see the humanity of every American, who will have a courageous empathy to understand their circumstance and their struggle, and put that in accordance with the values of a nation where we all swear an oath for liberty and justice for all the people. Over 75 years ago, Justice Hugo Black encompassed the basic ideal of the role of federal courts in protecting citizens' rights when he wrote these words, and I quote, "No higher duty, no more solemn responsibility rests upon this court than that of translating into living law and maintaining this constitutional shield deliberately planned and inscribed for the benefit of every human being subject to our Constitution, whatever race, creed, or persuasion." Yet Judge Gorsuch's own writings demonstrate a failure to grasp this understanding of the role of courts to protect all people, and I quote again Justice Black, "whatever race, creed, or persuasion." In an opinion article for the National Review entitled "Liberals and Lawsuits," Judge Gorsuch expressed his skepticism about civil rights litigation. His skepticism of civil rights litigation as merely a pursuit of a social agenda. He wrote, and I quote, "American liberals have become addicted to the courtroom, relying on judges and lawyers rather than elected leaders and the ballot box as a primary means for affecting their social agenda on everything from gay marriage to assisted suicide to the use of vouchers for private school education. The overweening addiction," he writes, "to the courtroom as a place to debate social policy is bad for the country and bad for the judiciary." I wonder what Oliver Brown, plaintiff in the seminal case of Brown versus Board of Education, would say to Justice Gorsuch. Was he addicted to the courtroom to advance a quote-unquote social agenda, or was the courtroom his avenue to justice against profound oppression? I wonder what James Obergefell would say to Judge Gorsuch when he was he addicted to the courtroom? When he sought to be able to marry the person he loved? Or did Oliver just want to see the idea to make it true that separate but equal is actually discriminatory, demeaning, degrading, not just to the individuals who are discriminated against, but demeaning to us as a people and a nation? Judge Gorsuch's actions call into question whether he understands the proper role of the courts. Does he understand that federal courts are the proper forum for constitutional disputes, which protect Americans' basic rights? That this is not about liberal or Democrat. This is about individuals who are often fighting battles against powerful interests. It was a journalist and editor, William Allen White, who said in 1936, "Liberty must be something more than a man's conception of his rights, much more than his desire to fight for his own rights. True liberty is founded upon a lively sense of the rights of others and a fighting conviction that the rights of others must be maintained." I do not believe Justice Gorsuch possesses this fighting conviction that we need a Supreme Court justice to forcefully and fearlessly, without regard to politics or favor or privilege or wealth, protect the rights of others, to protect the rights of all Americans, to protect the rights of we the people. I do not believe that Justice Gorsuch will work to fiercely defend the rights of all Americans. I do not believe he possesses that fighting conviction that we the people must be committed above all else to one another. Again, I do not take the decision to oppose Justice Gorsuch's nomination lightly. I understand what is at stake here. I am fortunate to represent hardworking New Jerseyans in the United States. And when I took the oath to support and defend the Constitution, I made a promise to my constituents and the American people not to only discharge my duties, but to, at every opportunity, to work across the aisle to protect their rights and interests. That means a lot to me. So many of my most proud moments in the Senate are from this bipartisan cooperation that I found with so many of my colleagues. I do not stand here today to question their motives. I do not stand here today to impugn them in any way. Because when I go home, people are not concerned about the partisan politics. They're concerned about their lives, their livelihoods, about the issues that affect them and their families, their neighborhoods, their community. They want people in this body and in the courts across the street to protect the rights of Americans, to protect consumers, to protect our kids and our environment. But this is, in fact, what I believe the nominee we are all considering has shown that he will not do. It is no secret that Judge Gorsuch's nomination comes at a very divisive time for this body and a challenging time for our country. We have experienced great times of turmoil and polarization before in this nation and in this body. In the Federalist Papers written over 2 centuries ago, James Madison warns in Federalist Paper number 10 about what he calls the mischiefs of factions and its inevitability, that citizens in the nation and their political parties will undoubtedly disagree and will possess competing interests. Madison asserted that the existence of the legislative branch would guard against some of the worst effects of this reality. He wrote that those elected to represent the American people in the legislature would be those, and I quote here, whose wisdom may best discern the true interest of their country, and whose patriotism and love of justice will be least likely to sacrifice it to a temporary or partial considerations. When this body is at its best, I believe that's true, and I've seen that kind of partnership in this body. But I'm afraid that we are indeed at a troubling time in history for the United States Senate, where it seems that the reverse of Madison's hopes have become reflective of the truth we're experiencing. Because we're now facing a vote on a Supreme Court nominee whose confirmation, I believe, would be a sacrifice to temporary and partial considerations as opposed to the larger interests of our country. And in my short time in this body, just over 3.5 years, I've come to this floor to speak on nominations of 2 different Supreme Court justices to serve here in the United States. The first was Chief Justice Merrick Garland. He was not only well qualified, intelligent, and capable, but he was moderate. President Obama even sought input from Republicans about choosing someone who was a mainstream jurist. He was more than qualified to sit on the Supreme Court, but he was actually someone who could bring folks together. His qualifications, his aptitude to serve, and his moderate philosophy was not displayed, was not reflected in how we dealt with that nomination. I believed he deserved an up or down vote. Even if it was a 60-vote threshold, he deserved an up or down vote. More than this, he should have had the opportunity to meet with senators, Republican and Democrat, like Gorsuch has met with senators, Republican and Democrat. He deserved to have a committee hearing. He deserved to be voted on, up or down, in that committee, and he deserved to have his nomination to come to the floor, whether a 60-vote threshold or a 50-vote threshold. He deserved an up or down vote, but he did not get one. The Garland nomination was blocked, the bookend to an era we have been experiencing. I've been witnessing of obstruction. And there have been finger-pointing on both sides, but let's be clear what happened during the Obama administration. During President Obama's time in office, we saw historic obstruction like never before. 79 judicial nominees of President Obama were blocked by the filibuster. 79 nominees were blocked at a time that the Judiciary, the independent branch of government, was saying we are in judicial crisis in many jurisdictions. 79 of Obama's justices were blocked, compared to 68 nominees obstructed under all presidents combined. From George Washington to George Bush, all of the obstruction from Democrats and Republicans and other parties, only 68 nominees were obstructed compared to President Obama, where there was 79. I do not possess the same view as those who last year believed this seat should remain vacant and took the obstruction during the Obama presidency to a much higher level. I believe that seat should have been filled, not by an extreme jurist, but by someone who could have tempered the partisanship of our time, someone who could have brought us together. It was a wise choice at a divisive time in our country. President Obama did not choose somebody from further left. He chose a moderate justice who probably could, if he was given an up or down vote, commanded 60 votes. And at this time, that's what President Trump should have done. put forward a nominee that could have brought this country together, a moderate nominee, someone within the judicial mainstream. But he hasn't. I believe the 60-vote threshold right now is more than appropriate at this moment in history. There are Republican judicial nominees that could garner 60 votes in this caucus, in this chamber. The 60-vote threshold exists because the person confirmed to serve on the Supreme Court at this time should be mainstream and independent enough to garner those two-thirds support. The 60 votes threshold exists because a confirmation of a justice to the Supreme Court is one of the most important duties that we perform, one of the most important positions in all of American government. It is someone that will have impact on our society, shaping it and forming it for generations to come. This president should have sought the real advice and consent from the entire Senate, but instead he turned to the judicial extreme. And now more than ever, we need a threshold that can pull our nominees back to the center, that could begin to heal the divisions. I do not believe it's in the best interest of my constituents or the American people to confirm someone so extreme on a 50-vote margin. It should be 60 votes. I urge my colleagues to understand that this justice threatens those ideals that we hold precious. Those words at the very beginning of our Constitution, we the people. I urge people to understand that this is a time more than ever that we must continue to fight to defend the marginalized, the weak, the people who don't possess wealth, the people who are standing against powerful corporations, that we cannot reverse a tradition where our courts were the main societal avenue in which people could receive equal justice under the law. We cannot put someone in office who is shown throughout their judicial record to be contrary to that. And for the sake of this body now more than ever, it's my hope that we can see a judicial nominee that will help to heal wounds and not create them, help to elevate the unity of us as a people, that will help to affirm the ideals of our nation and the very conception that we are one people, we are one nation, we hold one destiny. Mr. President, I yield the floor.
Mr. President.
Senator from Virginia.
Well, first of all, Mr. President, let me thank my friend, the senator from New Jersey, for his statement. I, too, share the belief that there was a better way to go about this judicial nomination process. I think as well that traditions such as a 60-vote margin should be maintained. I think, frankly, neither party comes to this issue completely with clean hands, with the Democrats' action in 2013, but clearly our colleagues' actions not even giving someone of such character as Merrick Garland the courtesy of meetings, a hearing, and then that up and down vote. And for that and for many other reasons, I will be joining my friend from New Jersey in voting against Judge Gorsuch and making sure that we use all of our available tools. So I thank him for those comments. But that sense of what we are dealing with now in our politics today is the subject that I want to speak to a few minutes about. And that is the incredibly important efforts made each and every day by our public servants. We often forget that our public servants, our federal employees, go to work every day with the sole mission to make the country a better and safer place. Day after day, they go to work receiving little recognition for the great work they do. Since 2010, I've come to the Senate floor to honor exemplary federal employees, a tradition that was begun by my friend, Senator Ted Kaufman. One of those federal employees is actually sitting at the desk and has helped me, and I know so many other senators, as we've tried to learn this job. The reason why I wanted to come back today was because today, in light of a government-wide hiring freeze, the reinstatement of the so-called Holman Rule, a proposed budget that would deeply cut our federal workforce,
And candidly, in these times, the targeting of career civil servants by certain conservative media outlets, this tradition of honoring those who serve oftentimes without recognition, our federal employees, feels even more important. Our federal employees, over 170,000 of them, Virginians, serve their country dutifully, regardless of the party in power. Not only do they carry out the mission of the administration that they are serving, but they also provide countless benefits to the American public. It's my hope that my colleagues and the current administration will remember these facts and set aside ideology when considering actions that affect our federal agencies and their workforce. So today I want to just take a couple of moments to recognize a few Virginians who are working behind the scenes to actually make our government more efficient and more effective. First, I'd like to recognize Kurt Yeager. Kirk is the chief explosive scientist at the FBI. And in this role, he both responds to crises and oversees the Bureau's efforts to better understand the explosives that terrorists use. Having studied bomb making for more than 20 years, Kirk works with both domestic and foreign law enforcement agencies and has developed and provided crucial training to every bomb squad in the United States and to many of our foreign allies. Through his work, Kirk has made the United States civilians, law enforcement personnel, and those who serve our country in the military much, much safer. Next, I would like to recognize Dennis Wagner. Dennis is the Director of Quality Improvement and Innovation Group for the Centers for Medicare and Medicaid Services. As part of the team at CMS, Dennis contributed to the creation of the Partnership for Patients, a public-private partnership to increase patient safety and reduce readmissions to U.S. hospitals. Their work has produced outstanding results, including 2.1 million fewer patients harmed and $20 billion saved. That's a remarkable statistic, and obviously the work going on at CMS, an agency that doesn't get a lot of recognition, candidly most people don't even know. A person like this gentleman, Dennis, has made our healthcare system actually better. Third, I'd like to recognize Edward Grace. Edward is the Deputy Chief in the Office of Law Enforcement at the U.S. Fish and Wildlife Service. In that role, Edward has been leading a nationwide law enforcement investigation known as Operation Crash, targeting those who smuggle and trade rhino horns and elephant ivory. In addition to assisting in the department's efforts to preserve global biodiversity, Operation Crash has led to 41 arrests, 30 convictions, and the seizure of millions of dollars in smuggled goods. Results that show that those seeking to engage in this kind of activity, there'll be real legal consequences to their actions. Finally, I'd like to recognize Mariella Mariello. Mariella is the Associate Director of the Customer Service and Public Engagement Directorate at the U.S. Citizenship and Immigration Services. Mariella and her team have been working to improve the way that USCIS interacts with the millions of people who contact their office seeking citizenship, permanent residency, refugee status, or other assistance. Central to that mission are the innovative improvements that Mariella has made to my USCIS website, as well as the launch of quote-unquote Emma, a virtual assistant that in a typical month answers nearly 500,000 questions with a success rate of nearly 90%. To ensure that this resource was available to a wide range of customers, Mariella also oversaw the creation of a Spanish-speaking Emma that came online in 2016. These important improvements have been crucial to driving efficiency for the world's largest immigration system in the world. Again, I hope my colleagues, as we think about budgets and numbers, and when we hear people who oftentimes denigrate our federal employees, will remember some of these individuals who, not for great reward or recognition, but actually get up each and every day and go to work trying to make sure that our government functions for the hundreds of millions of Americans who oftentimes don't acknowledge or recognize their services enough. As I mentioned at the outset, I know this is a time when most of my colleagues are speaking on Judge Gorsuch. I will simply add, after careful review of his record, and my belief as well that his unwillingness to really give truly straight answers in terms of comments, whether it was basic decided legal opinions like Brown versus Board of Education or Roe v. Wade or Citizens United, his failure to even answer those questions has unfortunately led me to join with so many of my other colleagues in voting against him. I still hope that there is a way that we can avoid changing the rules of the Senate during this process. And I know there are many colleagues who are working on those efforts, and if they're successful, I look forward to joining them. But as we think about Judge Gorsuch, as we recognize the challenges we've got ahead of us, let us all also who serve in this body continue to take a moment every day and to say thanks to a federal employee who, in one way or another, works tirelessly day in and day out to make our country a better place. With that, Mr. President, I yield the floor and note the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
President.
Senator from Delaware.
I ask that the quorum call be vitiated.
Without objection.
Thank you, Mr. President. Mr. President, last week on the Senate floor, I made the case for Democrats and Republicans joining together to confirm one of the most qualified individuals ever nominated to the United States Supreme Court. I was referring, of course, to Chief Judge Merrick Garland. I don't wish to belabor the point here this evening, but it bears repeating that Judge Garland brought with him more federal judicial experience than any Supreme Court nominee in the history of the United States. It bears repeating that Judge Garland is an extraordinary man, a good man, a brilliant man, a fair judge, and a consensus builder on the bench in a day and age when we need consensus builders on the Supreme Court and other courts across the country. And frankly, we need them right here on this floor, in this body. And it bears repeating that the obstruction of Judge Garland's nomination was unprecedented in the history of the United States of America and the history of the Senate. Since the Senate Judiciary Committee began holding hearings on Supreme Court nominations, I believe it was in 1916, no Supreme Court nominee had ever been denied a hearing and a vote. Since 1916. Until Judge Garland. Many of our Republican colleagues refused to meet with him. And when his nomination expired at noon on January 3rd, 2017, 293 days had passed. 293 wasted days. A good man was treated badly. I believe our Constitution was treated badly. I believe that the obstruction of Judge Garland's nomination was unprecedented. I believe it was shameful. From my view, we cannot pretend that this vacant seat on the Supreme Court, what I believe should be Judge Garland's seat, is the result of anything other than blatant partisanship. I believe that upholding my oath to protect the Constitution means finding agreement on moving Judge Garland's nomination forward at the same time as that of Judge Neil Gorsuch, President Trump's Supreme Court nominee. I have no choice but to oppose Judge Gorsuch's nomination this week, because anything else would be a stamp of approval for, I believe, is playing politics with Supreme Court nominees. I cannot support Judge Gorsuch's nomination because we cannot have one set of rules for Democratic presidents and another set of rules for Republican presidents. Some of my colleagues, and maybe some of the Americans listening at home tonight, may be asking themselves, well, Senator Carper, didn't Democrats change the rules for judges when they were in the majority? Fair question. And to that I would say yes, that's true for lower court nominees, federal district court, Court of Appeals. But it wasn't because Senator Harry Reid woke up one morning and decided that that was the day to change the rules of the Senate. A decision of this magnitude didn't happen on a whim. It was because by the time November 2013 had arrived, our Republican friends had attempted to block, get this, more nominations in the first 5 years of President Obama's tenure than all other presidents combined. Let me say that again. It was because by the time November 2013 had arrived, our Republican friends had attempted to block more nominations in the first 5 years of President Obama's tenure than all other presidents combined. And it wasn't the unprecedented use of cloture motions, 79 cloture motions, during those 5 years that precipitated Democrats seeking a solution to restore the capability of the Senate to do its job. It was because our Republican friends refused to consider any nominee to the D.C. Circuit Court of Appeals, despite 3 critical vacancies on our nation's second highest court. So yes, it's true that Democrats supported a change that allowed a vote on those nominees, but it was because our Republican friends took the unheard of position that no nominee, no matter what their qualifications, was entitled to a vote. I should note that Democrats were careful to preserve the 60 votes for Supreme Court nominees. Let me just say, if there's any position in the federal government to require at least 60 votes, my view is it should be the Supreme Court. And that is the rules under which we operate as of this moment. And one of the reasons why is because Supreme Court vacancies come around quite rarely. And when they do, we need to ensure that debate is robust. We need to ensure that the nominee is from the judicial and the political mainstream. And we need to ensure that these lifetime appointments are held to highest standards. In other words, I believe we need a nominee like Judge Merrick Garland. Despite his own impressive resume, I have concerns with Judge Gorsuch's nomination beyond the treatment of Judge Garland. And I have concerns with the way that our debate has not been, frankly, robust. I have concerns that Judge Gorsuch's views are outside the judicial and political mainstream. And I have concerns that what others have termed evasiveness, but his evasiveness before this Judiciary Committee does not meet the high standards that we should expect for these lifetime appointments. Mr. President, I would be remiss if I did not mention what I referred to last week as the cloud that lingers still over President Trump's campaign. Like many Americans, I read the news related to Russia and the Trump campaign, and I come to the inescapable conclusion that the cloud is darkening and the forecast is a matter of grave concern for our Constitution. FBI Director Jim Comey has testified under oath that there is an ongoing investigation to determine the links between the Trump campaign and Russia, an adversary that attacked our election and undermined a free and fair election to change the outcome of that election. And from all appearances, they did. To hastily move forward with Judge Gorsuch, who is 49 years old, who could serve in the Supreme Court well into the middle of this century, without first getting to the bottom of the suspicious and irregular actions of Trump campaign officials, would be, in my view, a mistake. So, Mr. President, for many Americans, this Supreme Court seat will always come with an asterisk to it. An asterisk. I believe that it was a stolen seat that belonged to Judge Merrick Garland. And many Americans are wondering why we're rushing to fill a lifetime vacancy while President Trump's campaign remains under investigation, and will for at least some while. Mr. President, I believe we have some time. Judge Garland waited 293 days for a hearing and a vote that never came. Judge Gorsuch has waited 48 days for a hearing, and many of our Republican friends would like to see him seated this week. Again, I would say Judge Merrick Garland waited 293 days for a hearing and a vote that never came. But what we face here today, I think, is a rush to judgment. And I would just say we have time. We ought to hit the pause button on this nomination. The American people are watching us, and history will judge us. I fear that history may judge us poorly if anyone other than Merrick Garland is confirmed at this time. I fear that history may judge us poorly if we do not insist that the Trump campaign is first cleared of any wrongdoing before we move forward. We need to get this right. We have time to get this right. Mr. President, the Senate has been through it all. The good men and women of the Senate have always disagreed, sometimes passionately, oftentimes loudly. And I understand that this disagreement before us may seem unresolvable. But that is only if we seek to cut off debate and admit defeat. Personally speaking, I'm not ready to do that today or this week. I believe we have time. I believe we have the opportunity to right an historic wrong. Not just an opportunity to right an historic wrong, but an obligation. We have the opportunity, I think, an obligation to get this right. And with that, Mr. President, I yield the floor to my friend from the state of Oregon. No? All right. I yield the floor, Mr. President. And with that, I note the absence of a quorum, Mr. President.
Clerk will call the roll.
Mr. Alexander.
Majority Leader.
Are we in a quorum call?
We are.
I ask unanimous consent that further proceedings on the quorum call be dispensed with.
Without objection.
Well, Mr. President, it's pretty obvious, based on the announcement that senators have made, that we are experiencing here the first partisan filibuster of a Supreme Court nominee in the history of the country. We've had plenty of time to discuss Judge Gorsuch and his credentials both in committee and on the floor, and I think it's now important to move forward. And therefore, I send a cloture motion to the desk for the nomination.
The clerk will report the cloture motion.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, do hereby move to bring to a close debate on the nomination of Neil M. Gorsuch of Colorado to be an Associate Justice of the Supreme Court of the United States, signed by 17 senators
I
as follows.
consent the reading of the names be dispensed with.
Without objection.
I ask unanimous consent the Senate be in a period of morning business with senators permitted to speak therein for up to 10 minutes each.
Without objection.
I ask unanimous consent the Judiciary Committee discharged from further consideration. The Senate now proceed to S-Res 94.
The clerk will report.
Senate Resolution 94, designating March 2017 as National Read Aloud Month.
Is there objection to proceeding on the measure? Without objection, the committee is discharged and the Senate will proceed.
I ask unanimous consent the resolution be agreed to, the preamble be agreed to, and the motions to reconsider be considered made and laid upon the table.
Without objection.
Now, Mr. President, I ask unanimous consent that the Senate proceed to the en bloc consideration of the following Senate resolutions which was submitted earlier today: S-111, S-Res 111, S-Res 112, and S-Res 113.
Is there objection to proceeding to the measures en bloc? Without objection. The Senate will proceed en bloc.
I ask unanimous consent the resolutions be agreed to, the preambles be agreed to, and the motions to reconsider be considered made and laid on the table, all en bloc.
Without objection.
I ask unanimous consent that the debate time on the nomination of Judge Gorsuch during Wednesday's session of the Senate be divided as follows. Following leader remarks until 11 a.m. be equally divided. That the time from 11 until noon be under the control of the majority. The time from noon until 1 under the control of the minority. Further, that the debate time until 9 p.m. on Wednesday be divided in 1 hour alternating blocks.
Is there objection? Without objection.
I ask unanimous consent that when the Senate completes its business today, it adjourn until 9:30 a.m. Wednesday, April 5th. Further, that following the prayer and pledge, the morning hour be deemed expired. The journal of proceedings be approved to date. The time for the two leaders be reserved for their use later in the day. And morning business be closed. Finally, following leader remarks, the Senate resume executive session to consider the nomination of Neil Gorsuch as under the previous order.
Is there objection? Without objection.
So if there's no further business to come before the Senate, I ask to stand adjourned under the previous order following the remarks of Senators Rubio and Merkley.
Without objection.
Mr. President.
The senator from Florida.
Mr. President, I come to the floor today to discuss the issue of human rights as part of my office's ongoing efforts on a campaign we call Expression, Not Oppression. We highlight human rights abuses around the world and tell the stories of political prisoners and other brave leaders who are being repressed, jailed, beaten, worse, and they simply for criticizing the government of the nation in which they live. This is an important week for human rights. Two nations with concerning records regarding human rights, Egypt and China, have sent their heads of state to meet with our president. And I hope, the chance later on this week to discuss the issues that we confront in China, and there are many. Today I want to discuss the state of human rights and our general relationship with Egypt. Over the past 2 days, the president of Egypt, President El-Sisi, has been visiting our nation's capital. He had the opportunity to meet with the president and other officials in the administration, and earlier today I had the opportunity to visit with him as part of a meeting with members of the Senate Foreign Relations Committee. Before entering my remarks, I want to make abundantly clear we are incredibly impressed and grateful and supportive of the efforts that President El-Sisi and Egypt are undertaking battling radicalism and in particular ISIS. They are undertaking this effort, for example, in the Sinai, and it is quite a challenge. But I also understand that the ongoing ability to defeat radicalism in the world depends on the stability of our partners internally. And that is why the human rights situation in Egypt is concerning. I believe it is fair to say it is at its worst in decades, and that is saying something. It's important, some may ask, why does America care about that, and beyond, obviously, our moral calling to defend the rights of all people? It's that it's counterproductive behavior. These abuses, the conditions that exist in Egypt and in other places around the world, are actually conducive to jihadi ideology. The ability of recruiting people who feel vulnerable, who feel oppressed. They become more vulnerable to those campaigns when they feel that they are being mistreated. The current government of Egypt, under the leadership of President el-Sisi, has cracked down on civil society. On that, there can be no debate. They've jailed thousands of political prisoners, including, sadly, some Americans. And it has responded with brute force to those who oppose that government. Now, again, I want to reiterate, a strong U.S.-Egypt relationship is important to America, to advancing our interests in the Middle East. I'm here today to speak on behalf of American interests and why this is so important in our relationship with Egypt and in the stability of the region. But I must do so by describing the situation on the ground. We simply cannot, in the national interest of our country, turn a blind eye to the ongoing repression of Egyptian citizens by their government. It weakens our moral standing in the world, and as I have already said numerous times, it makes Egypt less secure. And if Egypt is less secure, ultimately America will be less secure. And today I said that to President el-Sisi. Over the last decades, the Congress has provided Egypt, the American people have provided Egypt, with more than $77 billion in foreign aid. This includes to what is currently $1.3 billion per year in military aid. But as the human rights situation in Egypt continues to deteriorate and the government refuses to take serious and necessary steps of reform and respecting the rule of law, then this Congress, on behalf of the American people who are giving $1.3 billion of their hard-earned taxpayer money, must continue to pursue reform of our assistance to Egypt to make sure that not only is it allowing them to confront the challenges posed by radicalism today, but it also promotes progress in a way that does not leave Egypt unstable and ultimately vulnerable in the future. It is in the interest of both our country and Egypt and the Egyptian people to implement reforms and to release all of its jailed political prisoners, including all jailed Americans. Nations cannot thrive and they cannot prosper if their citizens are oppressed or are unable to express themselves freely without fear of being jailed, tortured, or killed. Inevitably, if these conditions continue, there will be a street uprising in Egypt once again. And it could very well be led by radical elements that seek to overthrow the government and create a space for terrorism. Human rights abuses in Egypt take on many forms. For example, the lack of press freedom. In 2016, Egypt joined other nations in rising to the top of the rankings as the world's third highest jailer of journalists. According to the Reporters Without Borders 2016 World Press Freedom Index, Egypt currently ranks 159th out of 180 countries in terms of press freedom. The media, including journalists, bloggers, and those active on social media, are regularly harassed and arrested. There are currently 24 journalists jailed on trumped-up and politically motivated charges. The crimes, quote-unquote, have included publishing false information, inciting terrorism. Censorship has grown as they continue to interfere in the publication and circulation of news, although, by the way, a lot of Egyptian news coverage is very anti-American. These are just a few examples of the ongoing repression of press freedom in Egypt. There are also human rights abuses the Egyptian government continues to commit with regards to freedom of association and of assembly. In November 2016, the Egyptian parliament passed a draconian law that, if signed by President el-Sisi, would ban non-governmental organizations from operating freely in Egypt. The law would essentially eliminate all independent human rights groups. It would make it nearly impossible for charities to function by imposing strict regulations and registration processes. Individuals who violate this law could face jail time simply for speaking out and fighting to defend human rights. Passing laws like these has a chilling effect on dissent. Here's the good news. President el-Sisi has not signed it yet, over 4 months later. And I truly hope that it's because he's having second thoughts about it, because he recognizes the terrible impact it will have on its country's future, on their perception around the world, and on their ability to make progress and reform. And ultimately, because he also recognizes the impact it will have on free nations like the United States, who desires to work with Egypt on many issues of common interest. I strongly encourage President el-Sisi to reject that anti-NGO law. There's the issue of political prisoners. According to the Project on Middle East Democracy, since 2013, at least 60,000 political prisoners have been arrested in Egypt. 1,800 people have received death sentences, and what many organizations have described as politically motivated sentences. In 2014, President el-Sisi issued a decree that expanded the jurisdiction of military courts over civilians. As according to Human Rights Watch, since the decree was issued, the military courts have tried over 7,400 Egyptian civilians. Additionally, individuals have been victims of enforced disappearances in Egypt. They've claimed that they were tortured and subjected to other forms of abuse when they were taken. There's been little accountability for this excessive use of force. Egypt's repression isn't limited to its own citizens. There are currently a number of Americans in jail in Egypt. There's one American in particular I'd like to personally raise, the case of American-Egyptian citizen Aya Hijazi. Aya was arrested in May of 2014 along with her husband and other members of her organization called the Baladi Foundation, which works with abandoned and homeless youth, rescuing these young children off the streets. 3 years ago, she was arrested and charged with ridiculous allegations, including sexual abuse and paying the children to participate in demonstrations against the government. To date, no evidence has been provided to back these horrible allegations. Almost 3 years later, this American citizen remains in prison. Throughout that time, I and others here in the Senate have been calling for her release, and it's time for the charges against her to be dropped and for her husband and the other workers to be released immediately, because her case and many others like it are an obstacle to better relations. The Egyptian people deserve better than the brutal treatment they're receiving at the hands of their government. All human beings do. It's incumbent on us, the elected representatives of the American people, to make clear to friends, allies, partners, and foes alike that no matter what issues we're working with you on, negotiating a resolution to, or dealing with on some other way, we are not going to look the other way when human rights are being abused. We are going to encourage you to do reforms because, in the long run, that is in your interest and ours. We've seen in recent history the consequences when governments do not respect their citizens. It creates instability in these countries. Instability is the breeding ground of terrorists and radical elements around the world. And ultimately, those terrorists train their sights on us. As I told President el-Sisi today, Egypt is a nation rich in culture and history and has made extraordinary contributions to the world. It has made and played a leading role in fostering peace with Israel. But it faces a dangerous future if it does not create the conditions within the country where its people can live peacefully and securely without fear. Otherwise, Egypt remains vulnerable to the kind of instability we've seen in Syria and in Libya and in other countries, and that's why it should matter to the American people. I am disappointed that this issue of human rights did not come up publicly when the president met with the president of Egypt, and I hope that that will change in the weeks, days, and months to come, for it is in our national interest to further these goals. Otherwise, sadly, we could very well have yet another, and perhaps the most important country yet in the region, destabilized and ultimately left vulnerable to becoming a breeding ground for terrorism that ultimately targets our people and our nation. Mr. President, I ask consent that the Senate resume executive session and resume legislative session following the remarks of the Senator from Oregon, Senator Merkley.
Is there objection? Without objection.
Thank you. With that, Mr. President, I yield the floor.
Mr. President.
Senator from Oregon.
Mr. President, is there a quorum call in place?
There is not.
Thank you, Mr. President. I rise to address the nomination of Neil Gorsuch. And I'll start by noting that just moments ago, the Majority Leader was on the floor and did something that has never before been done in U.S. history. And that is, on the first day, indeed the first hours of debate on a Supreme Court justice on this floor, the Majority Leader filed a petition called a cloture petition to close debate. So here we are on the first day, just hours into debate, and the Majority Leader said, enough. We don't want to hear any more about this topic. We're going to shut down debate. Now, the rules provide some protection for this, and that is it can't be voted on until Thursday. So there's time between now and Thursday for us to air our views. But historically, often debates went on for a substantial amount of time, a week, some for many weeks, with no cloture petition being filed, no closing the debate, and certainly never before has the Majority Leader shut down debate, filed that petition on day one, trying to ram this petition through, this nomination through. Well, this is just a continuation of firsts. First events that do absolutely no credit to this institution, no credit to the Supreme Court, no credit to our nation. In fact, pose a substantial danger. It was just February 13th, a little over a year ago, that Judge Scalia, Supreme Court Justice Scalia, died. And almost immediately, the Majority Leader indicated that when the nomination came down from President Obama, this chamber would not exercise its responsibility of advice and consent under the Constitution, would not provide an opportunity for Merrick Garland to be able to appear before a committee, answer the questions of the committee members, the questions of Republicans and the questions of Democrats, so they could assess whether or not that individual was appropriate to serve in a Supreme Court seat. Majority Leader made it clear that there'd be no committee hearing and no committee vote and no opportunity to come here directly to the floor bypassing the committee. In other words, he closed off every opportunity for the president's nominee to be considered, and this is the first time, this is the only time that has happened in our nation's history when there was a vacancy in an election year. What is the essence of this extraordinary and unusual action in which this chamber fails to exercise its advice and consent responsibility under the Constitution? Were we at a time of war, like the Civil War, in which the Capitol at times was under assault? Were we at a moment in which the building was aflame and we had to flee, or there was some other significant threat to the functioning of this body? Was there some extraordinary set of circumstances, perhaps a massive storm headed for the nation's capital, that led for the Senate for the first time in U.S. history to say it couldn't take the time to exercise its constitutional advice and consent responsibility? But there was no storm, there was no fire, there was no threat, there was no earthquake, not anything that would prevent this chamber from doing its responsibility. Well, the president, he has a responsibility under the Constitution when there's an open seat, and that's to nominate. And he proceeded to consult with members on both sides of the aisle, and he nominated an individual, Merrick Garland, who had an extraordinary reputation and who essentially was considered to come straight down the main street of judicial thought, with opinions that were neither labeled progressive nor conservative, straight down the middle. The president made that nomination on March 16th, a month and 3 days after the seat became vacant. But that was the last action to occur. Last action this chamber took. A few individuals did courtesy interviews, knowing that it would lead to no committee hearing and no committee vote, because the majority team in this chamber decided to steal a Supreme Court seat. Again, such a theft never, ever has happened in the history of our nation. Oh, there have been substantial number of seats come open during election year, 16. There have been a substantial number of individuals who were confirmed to those 16 seats. And there were a group of individuals who were turned down by this chamber. But in all of the 15 cases that preceded the death of Justice Scalia, the Senate acted. The Senate exercised its responsibility. But this time was different. This time the majority said, we intend to pack the court of the United States of America. Not by adding seats to it, that wouldn't work under a Democratic president who could then nominate more individuals. No, to pack the court by taking this seat, failing to exercise the responsibility that each of us has under our oath of office of advice and consent, and send it in a time capsule into the next administration, hoping that that time capsule would be opened by a conservative president who would nominate someone who was very conservative indeed, to create a 5-4 bias. Now, what was that bias that the majority was looking for? Well, it wasn't a bias towards we the people. It was a bias towards the powerful and the privileged. But if you take a look at our Constitution, that initial opening of our Constitution, it does not say we the privileged and we the powerful. It lays out a vision of a form of government with checks and balances to be designed to function of, by, and for the people. And the majority was afraid that Merrick Garland would be just that kind of judge, who would call the balls and strikes under the Constitution in support of the constitutional vision, we the people. And they didn't want a judge that would call the balls and strikes under our Constitution. They wanted someone who would find a way to twist a case in favor of the privileged and the powerful. And tonight I'll lay out a lot of how they knew that was important, both from the perspective of the decisions of the 5-4 court that preceded the death of Justice Scalia, and also from the writings and the decisions of Merrick Garland, who found every opportunity to take a case, find some word, find some phrase, find some idea. To operate is not to operate, to drive is not to drive. That's just language from one case. Find some way to find in favor of the powerful over the people. Merrick Garland's nomination lasted 293 days. That is the longest time in Supreme Court history. Now, I'm going to turn and go through the election year vacancies, because I don't want folks to take my word for the case that the Senate has always done its job, through more than 200 years, has done its job until now. And so let's take a look at those vacancies. Now, there were a couple of cases, 3 cases, in which there was an election year nominee and the vacancy occurred after the general election. So this happened when President Adams was in office and President Grant was in office and President Hayes was in office. So there was very little time left in the president's term. Now, in a number of these cases, all 3, the president didn't change office until March of the following year. But the Senate didn't even need those extra 2 months that it had before we amended the Constitution. And so President Adams nominated John Jay. He nominated him 3 days after the vacancy occurred in the year 1800. And the Senate confirmed the nominee. Now, here's an interesting twist. The nominee then declined the position. You don't see that very often in the history of the Supreme Court. And then we go to 1872, when President Grant was president, and he had a vacancy occur on November 28th, just a month before the end of the year and a few months before the presidency would turn over, following the election, nominated Ward Hunt. But the Senate acted in little more than a week, and they confirmed him. They vetted him. They exercised their advice and consent responsibility, and they said, yes, this individual is appropriate to serve on the court. And then President Hayes. A vacancy occurred in December of 1880. We were in 1872, and nominated William Woods. And here we have a nominee being put forward just very shortly afterwards and confirmed. So that was the first 3. That's the set of cases that occurred after, the vacancy occurred after the November election in an election year. Well, let's look at the next set of vacancies. Now, in these cases, the vacancy occurred before the election, but the nominee wasn't nominated by the president until after the election. So again, the Senate had a relatively short period of time in which to act. So we have the August 25th vacancy of 1828 under President Adams. He nominates, quite a few months later, almost 4 months later, John Crittenden. And in this case, the Senate acted, but they acted to table the nomination. And so he was turned down. And then we had President Buchanan, 1860, nominated Jeremiah Black. And in this case, we have the nomination being made just days. Now, this looks a little strange to us because we think of the presidency as changing in January, but the presidency didn't change until March. The nomination occurred in February, and the motion to proceed was rejected by the entire body. So again, that nominee was rejected. And then we can turn to President Lincoln. The vacancy occurred in the month preceding the election. President Lincoln nominated Salmon Chase just after the election, and the Senate said, plenty of time, we'll review that. It was confirmed. And then we can turn to Eisenhower. Once again, a vacancy occurring just in the month before the election, just 3 weeks before the election. Well, Eisenhower didn't put a nomination to the Senate until January. But the Senate said, we have a responsibility, advice and consent. We will review it, we will vet the nominee, and we will vote. And they voted, and they confirmed. So that's the second set of nominations. That's 7 of the 16 nominations. So there are still 9 to go. Let's take a look at those. Now, in this case, the Senate had more time to act. The vacancy occurred before the general election. The nomination occurred before the general election. And before I go through them, let me just note that of these 9, the Senate acted. They acted to confirm in 1804, to table in 1844, to table in 1852, to confirm in 1888, to confirm in 1892, to confirm in 1916, to confirm again 6 months later, still before the election, 2 in the same year, and then finally in 1932, the Senate confirmed a nomination made in February 15th. The Senate still acted. And these individuals, of these nine, we have 6 who were confirmed, 2 were tabled, but I've left 1 out. There's 1 more nomination that occurred in an election year. Just 1 more. And that happened last year. Under President Obama, we go back to Antonin Scalia dying on February 13th, and Merrick Garland being nominated March 16th. So of those 16 that we've looked at, the previous 15, Senate acted each and every time because they had taken an oath in office to uphold the Constitution that has a requirement that the Senate participate in advice and consent. But this time, no action. No action. No committee hearing, not a set of committee hearings, not even 1. No vote in committee, no effort or acceptance of moving the nomination to the committee of the whole, which would be here on the Senate floor. For the first time in U.S. history, the Senate stole a Senate seat from 1 president in order to pack the court. I've got to tell you that it isn't just a clever new tactic. It isn't just an excessive exercise of partisanship. This is a crime against our Constitution and the responsibilities of this body. This effort to pack the court is a major assault on the integrity of the court. Every 5-4 decision that we see in the future, everybody's going to look to say, 5-4, how would that be different? And it'd always be different if the stolen seat and the judge that fills it is on the winning side, because that side would otherwise have lost. A tie goes to the lower court's decision. So what this does is not only change the trajectory of our Constitution from one where it's designed for we the people to a different vision of government by and for the powerful. It doesn't just change that trajectory, but it draws into question everything the court does in the future. Wouldn't it have been incredible if President Trump's nominee, knowing the constitutional responsibility for the Senate to act, knowing that the Senate seat had been stolen from a previous president, knowing that it would bias all the outcomes of the court in the future, had stood up and said, I will not participate in this crime against the Constitution, and decline the nomination? Wouldn't that have been an act of integrity? Well, we didn't get that act of integrity from President Trump's nominee. And so here we are today on the first day of the Senate deliberation on this nominee. And just moments ago, the first time in U.S. history that the majority has exercised a petition to close debate on the first day of a Senate debate on a Supreme Court justice. Why is a majority in such a rush? Why is the Senate majority determined to push this through so quickly, in contravention of the tradition of due deliberation on this floor. I know that if the circumstances were reversed and the Democrats had participated in stealing a seat from a Republican president, my colleagues would be screaming on this floor, and they would be fully justified. And I'm proud that my colleagues on this side of the aisle have never participated in such an assault on our Constitution or a failure to exercise our responsibilities under our oath of office, or a theft of a Supreme Court seat, or an effort to pack the court. But if we had, my colleagues across the aisle would absolutely be standing and saying what I'm saying tonight, that this is wrong, this is destructive, this is damaging, and we should stop and rethink this. Because there's really only one nominee who would be a legitimate nominee for President Trump to make. Only one way to heal this massive wound, this massive tear and rip in the heart of our Constitution, this massive failure of this Senate body to do its job. There's only one nominee that can heal that, and that is for President Trump to nominate Merrick Garland, for him to get that committee hearing, for him to get that committee vote, for him to get that deliberation here on the floor. And maybe he would be approved, and maybe he wouldn't, because that's what we see every time the Senate has acted. It has not always been to confirm a nominee, but it has acted and deliberated and voted and decided as the Constitution calls upon it to do. That would be a healing of the wound. It would be a healing of the wound if the senators were to vote the same way they would have voted last year had there been a completely legitimate, ordinary consideration. And then we could go forward without this damage. So I call upon my colleagues, who I know have each and every one of them considered that it is their responsibility to build up, strengthen our institutions of government, not to tear them down. Therefore, I call upon them to reverse this deed before the dark act is completed of stealing a seat and packing the court. I want to turn to consider another piece of this puzzle. If the seat hadn't been stolen, and we were simply considering President Trump's nominee under ordinary circumstances, what would we find? Well, we would find a far right-wing justice completely outside of the mainstream. Now, why is it that throughout its history, this body has honored a rule of having a supermajority needed to close debate on a Supreme Court justice? It has been to send a message to the president that you must nominate someone who's in the judicial mainstream, not way out one direction or another with bizarre findings that would undermine the integrity of the court, not a pattern of attempting to twist the law so that we the people lose and we the powerful win time after time after time. No, someone in the middle of the judicial mainstream. Well, that's certainly where Merrick Garland was. But that is not where Neil Gorsuch is. He is a lifelong conservative activist, rewriting the law to make it something that it was never intended to be. A Washington Post analysis of his decisions that have been considered by the Supreme Court found that he would be, by far, the most conservative member of the court. Not there with where Scalia was, not where Justice Thomas is, not where Justice Alito is. He would be the most conservative member of the court, to the right of Justices Alito and Thomas and Scalia. And I quote, "The magnitude of the gap between Gorsuch and Thomas is roughly the same as the gap between Justice Sotomayor and Justice Kennedy. In fact, our results suggest that Gorsuch and Scalia would be as far apart as Justices Breyer and Justice Roberts." That's the Washington Post. It's a pretty big gap way to the right. And let's take a look at some of the cases that lead to this conclusion. There is a case known simply as the frozen trucker case. Alphonse Madden, the trucker, was fired for refusing to freeze to death. After waiting more than 3 hours with a disabled trailer on the side of the road, he unhooked the trailer and he started up the cab and he went to get warm before he could return to meet the repairman for the truck. Now, why couldn't he just carry the trailer with him? The brakes were frozen. Why was he himself freezing? Because the heater on the truck was broken. He fell asleep for some hours, woke up, and his body was numb. He became concerned about his life. And so he unhooked the trailer, went to get warm, came back to meet the repairman. The Labor Department determined that under the Surface Transportation Assistance Act, he was wrongly fired because that act is designed to say that if you operate a truck in a fashion, if you refuse to operate a truck in a fashion that is unsafe for you, the driver, or unsafe for others, you can't be fired for that. Safety comes first. The whole message of the act, safety comes first. But in this case, Neil Gorsuch dissented. Now, he wasn't writing the majority opinion. He went out of his way to write a minority opinion. The 10th Circuit upheld the fact that he was correctly operating the truck, leaving the trailer behind. You could say, was he operating the full truck or part of the truck? The point is, the 10th Circuit said, yes, the firing was wrong. They upheld the Labor Department under the Surface Transportation Act, said he did exactly what the act was intended. You have to restore his job. The 10th Circuit said, yes, absolutely. But Judge Gorsuch went out of his way to write a dissent saying no. And it is completely taking words out of context and twisting them. I encourage you to read it for yourself because it is truly a bizarre opinion, an effort to find a way, some path to find for the company instead of the trucker, who was protected by the laws written and passed in this chamber and the House and signed by the President. That's how far out of the common sense and the theory of the law Neil Gorsuch is. Or let's turn to a case often referred to as the autism case. Thompson, R2 versus J School, or R2J School District versus Luke P. This case says a great deal. Because in this case, Judge Gorsuch tried to rewrite a law which is referred to as the IDEA law or IDEA law, Individuals with Disabilities Education Act, to effectively invalidate the law. The law written here was to ensure that individuals with disabilities were provided an education by the school district, not babysitting, but an education. Well, Neil Gorsuch rewrote that law to say babysitting's okay. Despite years of special education in a public school, Luke P., that last name with a P, Luke P. wasn't showing any progress at home, so his parents enrolled him in a private school that specializes in autistic children, where he made advances because the school district was only babysitting him. And they fought to get the school district to reimburse them. And Gorsuch ruled in favor of the school district. And the standard that he put forward was the standard that babysitting is okay, even though the law was written to do the opposite. Now, this decision that Gorsuch wrote, it's so far out of the mainstream, it's so far out of common sense, it's so contrary to the law written here in this chamber, that the Supreme Court, yes, our Supreme Court, our 8-member Supreme Court, proceeded to say 8-0, that is absurd and wrong, Neil Gorsuch, and they reversed him. When have we had a nominee reversed 8-0? When have we had cases like the frozen trucker case and the autistic child case, where he went to great lengths to find for the powerful over the individual? Or we can turn to the Utah en banc request, which means, and it's in a case called Planned Parenthood Association of Utah versus Herbert. En banc means that the entire bench hears a case. Neil Gorsuch was such an activist, so committed to undermining an organization, Planned Parenthood, that he took the extreme step of initiating himself an en banc review of a decision to block a Utah defunding effort. Governor Herbert of that state used the cover of false and misleading videos to strip Utah's clinics of their funding. He later, that is the governor, made clear in testimony that he was in fact punishing Planned Parenthood for its constitutionally protected advocacy and services, and that the organization had not done anything wrong. The 10th Circuit granted a preliminary injunction against Utah for violating the organization's, that is Planned Parenthood's, constitutional rights. The 10th Circuit decided this. But Neil Gorsuch, ever the activist judge, rewriting law to make it say the opposite of what was intended, sought to have a review by the entire bench. Now, let me explain, that is not normal. Other people may call for an en banc review because they don't like the outcome, but to have a participating judge on the 10th Circuit initiate that, that's unusual. It's a message to the world. Everyone pay attention to me. I'm an activist, far-right judge, and if you like that, someone who's going to find for the powerful and the privileged over ordinary people, pay attention. That's who I am. It's kind of like trying out for a future Supreme Court opening. Gorsuch's entire adult life has been a mission to revoke a lot of the norms that we have come to embrace in our pursuit of the transitions in our society and in our government as we pursue that constitutional vision of equality under the law, protections to vulnerable populations, to workers and to kids and to women and to minorities. But Neil Gorsuch doesn't like that arc of seeking to provide the protections our constitutional vision laid out. As far back as college, he was an ideological warrior who championed a severely reactionary worldview. In the conservative newspaper he started, he characterized efforts to fight racism as, quote, more a demand for the overthrow of American society than a forum for the peaceable and rational discussion of these people and events. Very strange way to characterize efforts to fight racism. No, racism, discrimination, is to slam the door of opportunity on American citizens because of their gender, because of their race, because of their ethnicity, because of their sexual identity. Slam the door and disrupt that opportunity for each and every citizen to be treated equally under the law. He also used the opportunity to advocate for social inequality, saying, "Men of different abilities and talents to distinguish themselves as they wish without devaluating their innate human worth as members of society," and argued that a responsible system required a governing class of men of exceptional political ability to make the big decisions for society. Well, not much equality of opportunity in that statement. And as a judge, in case after case, he finds expansive rights for corporations at the expense of their employees, consumers, and the public interest. We've talked about the frozen trucker case and the autistic child case. There's also the electrocuted mine construction worker case. A worker started a project a week after it had begun, wasn't trained on how this should be done. It was a training that was really required because of the highly dangerous circumstances. When you're operating an equipment near power lines, that is just a setting that everyone in the construction industry knows is extraordinarily dangerous. You can connect that equipment to the power line. Perhaps somebody has their hand on the side of the equipment, and the next thing you know, they're electrocuted. Well, the worker mistakenly brought a piece of equipment too close to that overhead power line, and it was the worker himself who was electrocuted and killed. And the Occupational Safety and Health Review Commission fined the employer for not properly training the worker under these dangerous circumstances. And the 10th Circuit took a look at it and said, yep, the company failed to do the proper training. And the result was someone lost their life. But Judge Gorsuch dissented. And he said there was no evidence that the company had been negligent. Really? Failure to train in a highly dangerous situation that results in loss of life? No problem there. Why should we require companies to train people in dangerous circumstances? Again, a complete lack of common sense, a determination to overturn what a review board had found, what the circuit court had found. Or we can turn to the Hobby Lobby case. In this case, Neil Gorsuch found that closely held for-profit corporations have the right to choose the contraceptive coverage or lack thereof for their employees, if doing so conflicted with the corporation's religious beliefs. Now, we didn't actually have corporations in the sense that we have them now when our nation was founded. There were some charters, but not the modern corporation in the sense that we have it. And yet, Neil Gorsuch said, we'll just give this corporation personhood, and we'll let a corporation exercise religious beliefs that overrule the religious beliefs of the individuals. But it was the individuals that the Constitution was written to defend. It was the individual's religious beliefs, the Constitution, Bill of Rights, was laid out to protect, not a corporation, but in a never-ending quest to find for the corporation, to find for the powerful, to find for the privileged, Neil Gorsuch twisted the law and found that path and laid it out. In writing a brief as a lawyer in 2005, Neil Gorsuch urged the court to ignore the statutory and legislative history of the Securities and Exchange Act, advocating that the court limit the ability of those defrauded by corporations to band together to seek redress. This really goes to the difference between we the people and we the powerful. We have a nominee before us right now who doesn't like the idea of individuals being able to operate with a class action suit against the predatory actions of a powerful corporation. In an article about the case, he launched into an attack on the lawyers who were providing the ability for individuals to challenge the very powerful corporation. And he said these are frivolous claims. Frivolous claims that take an enormous toll on the economy. They put a burden on every public corporation in America. And in fact, I'll quote his exact quote: frivolous claims impose an enormous toll on the economy, affecting virtually every public corporation in America at one time or another and costing businesses billions of dollars in settlements every year. He didn't like this burden on corporations to respond when they were challenged for predatory practices. Now, often the transactions between a company and an individual are quite small. Maybe they involve a monthly fee to access telecommunications services. Maybe they involve a purchase of a single consumer item that cost $50, but the corporation misrepresented what that item was, or didn't disclose that it had dangerous paint on it, or some other feature. And the only way that ordinary people, we the people, can challenge the predatory practice of a powerful corporation is to put their cases together in a class action suit so that everybody, the thousands of people who bought that $50 item, can say, hey, you're doing something wrong. You're selling something dangerous and not telling us. You're selling something our children will choke on and not telling us. You're defrauding us in any of a whole series of possibilities. Perhaps it's in stock cases or other financial transactions. Perhaps it's the way mortgages are constructed. But the individual couldn't possibly take on the powerful company's room full of top-notch lawyers to reclaim that $50 or that small, modest sum. So a class action is the tool through which the people, we the people, proceed to take on the powerful. And Neil Gorsuch doesn't like that. And he doesn't like workers having the chance to confront corporations on the issues of sexual harassment. In Pinkerton versus the Colorado Department of Transportation, Judge Gorsuch joined an opinion discounting Pinkerton's evidence of discrimination and concluding that Pinkerton's performance, not discrimination, resulted in her termination. And Judge Gorsuch dissented from an opinion that, by very nature saying dissent, the majority found a different path, holding that Strickland provided ample evidence that she was regularly outperforming her male colleagues and yet was treated less favorably than them. And the list goes on, removing federal government protections in a variety of cases. But there is a third big problem with the fact that we are here tonight considering this nomination. The first big problem was the seat was stolen by the Republican majority. First time the theft like that has happened in the history of our nation in an effort to pack the court. That is a big deal. The second is that Trump nominated somebody completely outside judicial mainstream. The third is something that should give every American pause, and that is that at this very moment, investigations are taking place into the conversations, into the meetings between the Trump campaign and the Russians. Now, we know it's very, very public that the Russians conspired to affect the outcome of our presidential election. We know the tactics they used. They wrote false news stories. They proceeded to have a building with hundreds, I'm told 1,000 people in a building doing social media commentating to try to have people in America see those comments and go, oh my goodness, isn't that Democratic nominee terrible? Look what happened. An effort to give, in other words, some sort of validation to the false news stories that they were creating and to spread those false news stories via social media. We know that Russia used a series of bots, basically computers around the world designed to reply automatically on social media and Facebook, and to do so in order to make it look like there were more than 1,000, there were millions of people out there commenting on how terrible the Democratic nominee was. So they amplified this message with the goal of causing the algorithms used by companies like Facebook, of affecting those algorithms so that Facebook would start streaming the false news on their Facebook site. So an ordinary citizen would see that and go, oh my goodness, this must be true, it's on Facebook. Those are the core strategies the Russians used, and I'm not sharing with you anything that's classified. I don't serve on the Intelligence Committee. All of this is in the public realm. And the FBI is investigating not whether all that took place, so they continue to look to see what else and the details of that, but whether there was coordination, collusion, cooperation with the Trump campaign in how they did this. Let's be clear. The investigation is not concluded, and we don't know the answer. We don't know if the Trump campaign coordinated with the Russians. But let's also be clear about this. Anyone on that campaign who collaborated with the Russians to affect the outcome of the U.S. elections has committed a treasonous act. And so we have this cloud of this investigation over us right now. Will we find out in a few weeks that there were treasonous acts that completely delegitimize the election that put Donald Trump in the Oval Office? Will we find that? We don't know the answer to that. But what we do know is that we have at least a risk of being in a situation where a swing vote on the Judiciary, on the Supreme Court, is coming from a team that is being investigated. And let's get to the bottom of that and therefore know whether there is an issue of illegitimacy before we complete this conversation about filling this Supreme Court seat. There is an enormous amount of evidence that the Trump campaign was familiar with the efforts of a foreign power to alter the outcome of the election. And the names have come up in the press: Paul Manafort, Michael Flynn, Roger Stone. Other figures in the Trump orbit are under scrutiny for that. Several of them, the communications have been articulated where and how, and that cloud is very, very real. We had the unusual event a week ago Monday in which the director of the FBI came here to Capitol Hill to talk to the House and to say that it's not normal to confirm that our investigations are underway, but that he thought under this circumstance it was appropriate that he do so. So those are the three big issues that we are facing. And it's why every senator who values this institution, each senator who has pondered their responsibility under advice and consent and the theft of the Supreme Court seat last year, who recognize that the administration is under a big cloud and that cloud has not been resolved in terms of the legitimacy of the election or whether there was collusion with a foreign power. You know, I said that if there was collusion, it was a traitorous act. Here's why. Attacking the integrity of our elections, as Russia did, is an act of war on the United States of America. It's attacking the fundamental institutions of our democracy, of our democratic republic. We must never let this happen again. We must work with other democratic republics to make sure that Russia isn't able to do it in other countries, which we know that they are attempting to do in other elections. But we should absolutely get to the bottom of it before this chamber takes a vote on whether to close this debate or before it takes a vote on whether to confirm the justice. So that is the very broad presentation of the three big reasons we should pull the plug on this nomination, or at least put it in deep freeze until such a time as the Russia investigation is completed and that we have already considered Merrick Garland. That's what we should do. And I'm going to spend considerable time going into more details about these three issues. Because in my time in the Senate, there has not been an issue that had such grave consequences for the integrity of our nation, the integrity of our Senate, our integrity of the Supreme Court, and quite frankly, the integrity of the presidency as well. It affects all three branches. Because this crime of stealing a seat couldn't be completed without the direct involvement of the executive branch nominating Neil Gorsuch. So, I will go back over each of these in much greater detail. And as I was pondering why I feel so strongly about this, apart from the reasons I've already laid out, is that for generations to come, this chamber will be compromised. For generations to come, the Supreme Court will be compromised. And if we act together, if we hit the pause button, perhaps we can prevent that. And so I feel more compelled to be here and to raise my voice and to call for those who care about our nation to stop this insanity of this judicial nomination discussion here on the floor of the Senate. That's why I'm going to go on for some time exploring this. Now, you think back about when I came here in 2009. When I came to the Senate, my memories were of the Senate from the 1970s and 1980s, which makes me really now an old guy. I was able to come here as a 19-year-old as an intern for Senator Hatfield. And at that point in time, there wasn't a camera on the floor of the Senate, and there wasn't email, and it wasn't easy to get a document across the Capitol Hill in a short time. Interns were put to work running paperwork around the Hill. But I'll tell you, the institution was in a very different place. So I came here, I was the third of three interns to arrive that summer of 1976, our bicentennial summer. And the most recent intern is put to work, opening the mail each morning. And so I came in early. We'd have about 100 letters and envelopes. You'd run them through a machine that sliced the envelopes open. You stack up all the letters, you start going through them and say, well, this one is on this topic, and this goes to this legislative correspondent. Oh, this one's on this topic, and it goes to that legislative correspondent. And I think there were 3 or 4 in the office of Senator Hatfield. And you'd go through those 100 letters, and you'd put them on the desk of the legislative correspondent, and those correspondents had the newly developed electronic memory typewriters. And they had written paragraphs to respond to different topics. And they would mark on the letter the different paragraphs that should go. Here's the introductory paragraph we'll use. Here we need to address this issue in this letter, so that we'll use paragraph 56 from the memory bank, and we'll use number 84 to address another issue. And then those letters, all marked up, would go to the typing team that would run those memory typewriters and get responses out before the day was over. And I saw a lot that summer. One was that it was possible to actually get mail come directly in because we didn't worry about white powder being inside the envelopes. Now, if you write an actual physical letter to a senator in this chamber, it goes through a warehouse. It goes through a warehouse where they have to examine it and check it for poisons before it can be delivered to Capitol Hill, and it will take weeks. And people knowing this often choose to write by email, so most of the mail comes in electronically. But that summer, one of the legislative assistants was leaving for an extended period for a vacation in South America, and he was looking to have someone take over the Tax Reform Act of 1976. And I was asked to take over working on that act. And so what that involved was that you would look at all the mail that came on that tax topic, and you would research those issues, and you would draft responses, and those draft responses would go up and be approved or modified by the legislative director and by the senator, and then you would make sure those got into the database and that people got their questions answered. And I learned a lot about taxes that summer of 1976. I must say, when I was first asked to work on taxes, I was kind of disappointed because I thought, it'll be really interesting to work on education. It'd be really interesting to work on healthcare. It'd be really interesting to work on the environment. It'd be really interesting to work on jobs policy. Taxes? Not so interesting. So the next few days, as I threw myself into drafting responses to these issues being raised in letters, I was transformed, in my opinion, about working on tax issues, because the taxes affect everything in our body of law. Taxes have environmental consequences, or they may be an environmental incentive, such as the provisions we have in the tax code to encourage people to insulate their homes or drive a non-fossil fuel burning car. And they affect health, such as the provisions we have in the tax code that proceed to say that if your employer provides health insurance, it's not considered taxable income. And it affects job incentives. It affects everything. There were farmers writing in about tax issues that were being raised. There were teachers writing in. The teachers were concerned that there was a home office deduction that was on the chopping block. What this meant, if you used a bedroom in your home or a study in your home as your office to work as an elementary teacher or a high school teacher, you could deduct the cost or the value of that portion of your house as a work expense. Well, often when there's an opportunity like that, some people expand the definition of the office to a point in which it's ridiculous. And there were some individuals who were saying, well, now my entire home is my office. I'll deduct the entire cost of my home, which was never the intention. But teachers were concerned that in the course of correcting that they might lose the deduction that was a legitimate work expense. There are dozens and dozens of these things. So the bill happened to come up on the floor of the Senate, on this chamber, right here. And because I was working that bill, I was assigned to come over and follow the debate. I was up in the seats up above, and we considered amendment after amendment after amendment. Now, there was no negotiation between the two sides over what amendment would come up next. Once one amendment was finished, there would be a group of senators trying to get the attention of the presiding officer. And whoever got that attention first, whoever was fastest or loudest and was called on, their amendment was next. And they presented it, and the staff hovered around following it and trying to get a copy of it and trying to analyze it. And then we'd run down when the vote was called and meet our respective senators coming out of those elevators that are just through those doors right there, those beautiful double doors of the Senate. And I would stand there, and out would come Senator Church, and out would come Senator Goldwater, and out would come Senator Humphrey, and out would come Senator Kennedy and Senator Inouye, and then my senator would come out, and I'd say, okay, here's the story. Here's the amendment. Here's what it does. Here's what people have said about it. And he'd come in here and vote. And that was a very lucky set of circumstances that I had. But it allowed me to sit up in the chamber and watch this Senate. And you didn't have a cloture petition on anything. A cloture petition, meaning a petition to close debate. No, there was mutual respect. There was a determination of this body to give people a chance to say what they wanted to say, but very rarely did people go on at length, and more rare than that would be the case where a petition was filed to shut down a debate. You know, the principle, the idea that originated with our original Senate was there is time for everyone to make their views known to each other so we can benefit from their insights, that we can benefit from their life experience, and then we can make a decision. So it was a mutual courtesy among senators at the very start of our democratic republic. I saw that courtesy here on the floor as an intern 41 years ago. What a difference it is today, where today, for the first time in U.S. history, the majority filed the petition to shut down debate on the first day of a debate over a U.S. Senate seat, under circumstances that are more complex and more disturbing than virtually any circumstances we've seen in more than 200 years over the nomination of a Supreme Court justice. The first time in U.S. history that a nominee in an election year was not accorded any consideration. The first time a seat was stolen. Perhaps the first time that a cloud hung over the nominating president, President Trump, and his team because of the way the campaign was conducted and possible collaboration with Russians. And certainly one of the first times, because since the analysis have found that the views of Neil Gorsuch are to the extraordinary far right, that too adds a certain change from the tradition with the supermajority of a president nominating from the judicial mainstream. So we have these complex set of circumstances that should be thoroughly vetted. Should be a situation where no member of this chamber would even think about filing a petition to close debate. Wouldn't even consider the possibility of trying to cut off debate. Debate's gone on in Supreme Court, folks, for weeks and weeks and weeks without a petition being filed. And sometimes that nominee was confirmed, and sometimes the nomination was withdrawn. And in the course of it, the American people learned a great deal, and they were riveted to that conversation. But this time, the majority says that 200 years of history, that 200 years of developed comity here in the Senate chamber, the traditions that were still here when I was an intern 4 decades ago, we're going to wipe that away. Well, that's of great concern. And after I was here for a summer, I was very intrigued by the beauty of what we do on Capitol Hill, the profoundness of what we do on Capitol Hill. We can make a policy that can destroy home ownership for literally millions of families. Or we can make a policy that creates the opportunity of fair home ownership for millions of families. That's the power of the discussions that take place on the floor of the U.S. Senate, of this chamber, and the chamber on the other side of Capitol Hill. So during that summer, I was wrestling with a question. And that question was, my talents are in math and science, but is there a way to pursue a career dedicated to making the world a better place? Is there a way to actually pursue public policy as a career? And I didn't know the answer to that question. I went back to college for one trimester and out in California. And at the end of that trimester, President Carter was going to be inaugurated in January of 1977. And I thought, it'll be very interesting to see what a new president does. Let's see what policies he puts forward, how he builds his executive team, how he delivers his ideas to Capitol Hill, how he works with Capitol Hill. And so in January, I took a Greyhound bus across the nation, arrived here, and proceeded to work a variety of internships while also waiting tables and washing dishes. I worked as a hotel desk clerk up on 14th Avenue on Thomas Circle, and I worked washing dishes and waiting tables for Alum's Restaurant, which is kind of a sit-down hamburger joint. But it was also, I could be here and see the magic of public policy and the work done that could affect millions of lives here in this chamber, the work done on the far side of Capitol Hill that would affect millions of families, to the better or to the worse. And in the course of that year, I interned for a group called New Directions. It was an environmental nonprofit working on law of the sea. There was a question on outside of our territorial boundaries, will the nations cooperate so we don't destroy the resources in the international space of the oceans? And how far should our national space extend? And how do we write those rules so that our continental shelf is clearly under our control? Those are the sorts of questions we considered. That treaty, the Law of the Sea Treaty, that has never made it here to Capitol Hill. Every time there's a new presidency coming in, someone says, hey, remember that treaty from 4 decades ago? It might really strengthen U.S. control of our offshore areas. And maybe we should bring it up for discussion. It still hasn't been discussed here. But I also went door to door for work for a group called Virginia Consumer Congress. And they were working to create attention to consumer protection issues in the state capitol in Virginia. And they would go door to door, they'd have a team go door to door, and you would proceed to explain the issue that you were working on, the bill you were working on, the organization was working, ask ordinary citizens to sign a petition in support of that bill being considered at the Capitol. And you would ask, would you like to support the work of this organization so we can keep doing it? And if they made a donation, that helped strengthen the organization. This was the model that became the Public Interest Research Group model, the PIRG model. And specifically, the issue we were working on as we went door to door was to say we can save consumers a huge amount of money if we can simply implement peak load pricing. Now, what is peak load pricing? What it means is that you have a meter that when there's a huge demand for electricity, it charges a higher price. And by so doing, it alerts the consumer, hey, don't use electricity now, use it at another time. Now, why would that save consumers millions of dollars? Well, here's why. The electric power company wanted to build a nuclear power plant to meet just the peak load. And so they wanted to build a very, very expensive nuclear power plant, which they would then charge all the utility customers for. And a lot of utilities, it's kind of written into the law that they receive a kind of automatic 8% return on whatever they invest. So there's an incentive for them to invest more. The more you invest, the bigger your revenue stream is. And that revenue stream is paid for by the citizens who buy electricity. So if you could convince the utility to, instead of building a nuclear power plant, putting in meters that would tell people, hey, don't use your dryer now, it's more expensive, and shift that peak load, then everybody benefited. You didn't have to have the risk of a nuclear power plant. At that point, we had a lot of concerns. We'd had a lot of difficulties in some of our plants with near meltdowns. And the idea that you could have a radioactive cloud or a China syndrome occur somewhere near a metropolitan area was a very scary thing. And so you simultaneously greatly improve public safety while saving people a huge amount of money. And so that's what we were petitioning people for, door to door. And it was my first the president of the board of VEPCO, Virginia Electric Power Company. I went to his and his wife's house. I didn't know it was their house at the time. Huge house in suburban Virginia. And the wife greeted me, and she talked with me about these issues. And she said, you know, my husband is president of the board of VEPCO. But the issues you're raising, I never hear them raising those issues, and these are good points you're making, so I want to buy the Virginia Consumer Congress newsletter, which was a $15 donation. That was the biggest donation in the door I ever had while I was working there. And many other conversations. But the reason I came back to be here for those first 9 months of the Carter administration was to continue to see, how does Capitol Hill work? How do nonprofit advocacy groups? How does a new administration work? How does the Senate work? Because the Senate was so near and dear to my heart after the internship with Senator Hatfield. And in the course of that year, I came to believe that there was a path to work on public policy, and I specifically decided to work on third world economic development. And part of the reason that I chose that area was that when I was in high school, I had a chance to be an AFS exchange student in Ghana, in West Africa. And there were only 6 exchange students sent to Africa outside of apartheid South Africa. And of those 6, 5 went to cities, and 1 went to a modest town with a family of very modest means. And I was the student who was sent to that very modest town, to the family of modest means. And the experience was that I was surrounded by people barely able to afford to eat, or sometimes not able to afford to eat. Now, my host family was middle class. They were middle class by virtue of my host father was a school teacher. Host mother was also a school teacher, one in a public school, one in a private school. And because of the connection to the public school, my host father, who, if I recall right, had a 6th grade or 9th grade education, but that was enough to be a teacher because he didn't have enough people who were high school graduates or folks who were college graduates. And he was afforded a government-built house that had 3 concrete rooms and screens over the windows to keep out the mosquitoes. And there was electricity in the house and an outlet, and the family had 1 appliance. And that appliance was an iron, to iron clothes. And every night, my host father would take the clothing that had been washed that day, and he'd iron the clothing, because nobody else could touch that iron, because that was the incredibly valued appliance. And they had one other thing that was considered a real amazing thing for a family to have, and that was a bicycle. They had a bicycle. And I wanted to borrow the bicycle to go outside this town and visit some very tiny villages. And my host father was so afraid I was going to break this bicycle, that I wasn't going to be careful, I was going to go through potholes, I was going to dent the rim, because this is such a valued commodity to the family. So I decided in college, after my time here in 1976 and 77, that I'd work on economic development overseas, because I'd seen the families that surrounded my host family often earning just $1 a day and trying to feed a family of 6 or 7. The children couldn't go to school because they had to go down to the main street running through town and try to sell things through the windows, because the only way that the family would eat was for every child to be working. Well, I tell you this because it is all tied in to how I view the sanctity of this room, this Senate chamber. Because events that were to transpire unexpectedly brought me back to Capitol Hill after graduate school. I pursued that path of working on third world economic development, and I thought I was going to spend my life overseas. When I graduated from college, I was hired for a job to work for the United Nations in the Philippines, and my job was going to be going throughout the region to evaluate UN development projects. What a perfect position to be able to see in multiple countries. It would have been in Malaysia, and the Philippines, and Vietnam, a whole host of nations evaluating projects on the ground and giving reports back, what's working, what's not working, and why. And it was a 2-year post, and so I was so excited about doing this. It just seemed like all life had come together. One, I was going to have a job after I got out of college, and I could start repaying those student loans. And, I just felt I'm landing on my feet. And I went down to the organization, the nonprofit at my university that would set up these jobs. And the individual who ran it said, "Jeff, come here. I've got a letter for you to read." And the letter said, the United Nations has just eliminated the position in the Philippines to evaluate those projects. And so suddenly my job, before I ever got on the plane, was gone. And I didn't get to go. And again, I was very worried, well, what am I going to do after I graduate? But I proceeded to go down to Mexico and work in a village with the American Friends Service Committee. And then I went to New York, and I worked an internship with the Carnegie Endowment for International Peace, working on a variety of international issues. And then I decided to join a friend, and we would go by the cheapest bus available from California to Costa Rica. And we would proceed to go through country after country, Mexico and Guatemala and Honduras. We bypassed El Salvador. We got off the Pan American Highway because in El Salvador, people were in 1980 were being pulled off of the buses and shot. And the other nations were in turmoil. It was a year after the Sandinista Revolution in Nicaragua. In Guatemala, there was an army group that was going village to village and killing the young men. A war between one group and another group. There was a lot of chaos there, but we went all the way through to Costa Rica. Then I worked in a village again and on an environmental project, and had a chance to work in India, expecting the whole time that I was going to be going overseas for my life. And you never know what door is going to close and what door is going to open. But after I got out of graduate school and was ready to go and fulfill this vision that I developed back in 1977 when I extended my stay here in D.C. and was doing these internships, I was at the World Bank. I was hired at the World Bank. And I didn't want to be at the World Bank for long doing mathematical modeling. I was doing the shadow pricing of petroleum products. And if that doesn't sound very interesting, well, it kind of is, actually. If you love how numbers can give you a vision of what's going on and how the imports and exports of oil products were right or wrong and expensive, and by understanding the shadow pricing, you could understand the challenges that various developing nations faced. But still, it was working with mathematical formulas and data here in D.C., and I wanted to be in the field. And so I was preparing to go to Southern Africa, where I had not been. And in that preparation, I was also applying for a presidential fellowship in foreign relations, and one of those openings was at the Secretary of Defense's office. And the Secretary of Defense's office each year would have 5 openings for presidential management fellows. And there was 12 finalists for this. And they called us in to do a final interview. And they had this big kind of arc of the high-ranking folks, civilian and uniformed, from the Secretary of Defense's team. And then they had a chair in kind of the middle of that arc. And I just remember thinking it felt like you were about to be interrogated. And it was kind of an interrogation. The first question I was asked was, we see here that you interned for Senator Hatfield, and he votes against all the defense appropriations. And you worked for the American Friends Service Committee, and they're a service arm of the Quaker Church, and the Quaker Church has a peace testimony. Why would we ever hire you here in the Secretary of Defense's office? And I thought that was a really good question. And I was kind of surprised that I was a finalist for a position. But I responded that national security is so much broader than simply military might, that it involves an understanding of culture, an understanding of history, an understanding of economic dynamics, an understanding of the things that trigger dissent and how it might be responded to, an understanding of alliances. And that all of these things put together enable us to have a foreign policy that is part and parcel of our national security. Well, I probably said a more complex version of that, but that was the gist of it. And they hired me. And the reason I took that job, rather than heading off to Africa, was because at that moment, the biggest threat to the world was nuclear power. Not nuclear power, electricity, but nuclear weaponry, atom bombs. And the fact is that we were so concerned that there might be a nuclear war that would destroy the planet as we knew it, certainly destroy the Soviet Union and the United States. And since that was the biggest threat to the world, I felt compelled to pivot from third world poverty to work on nuclear weapon policy. And I did that through the 1980s. First for the Secretary of Defense, and then for Congress, which now completes why I was telling you that story, because that brought me back to be in regular contact with this Senate, with this chamber, with the folks who worked here and were trying to figure their way through a series of difficult issues involving nuclear weapons. You know, outside of this chamber, in the path walking between the Russell office building, the curved path, and coming in the outside doors that are outside of these double Senate doors, there's a tree. And that tree is known as the Peace Tree. And it is directly connected to the work that was being done in this chamber on nuclear weapon policy. So you had Senator Hatfield and Senator Kennedy were working together, a Republican and a Democrat, working together to try to address the risk of nuclear weapons. Well, in 1985, there was an intern walking with Senator Hatfield. He liked to walk outside along that curved path back to the Russell office building. It's a path I'd had the chance to walk with him a number of times on, and he'd talk about the different trees along the way. And I remember in particular his lecture to me on the ginkgo tree. There are several ginkgo trees out there between here and the Russell office building. Well, I was relaying this to a 1985 intern of Senator Hatfield's named Sean O'Halloran. And Sean said, you know, I had those same walks with Senator Hatfield, and he gave me the same stories about the trees. He was so interested in them. And then he said, so Sean O'Halloran said to Senator Hatfield, Sean O'Halloran obviously was much quicker to seize just the right moment than what never occurred to me. He said, Senator Hatfield, you love these trees so much. Why don't you plant one? And Senator Hatfield said, Sean, that'll be your intern project. And so Sean worked on this. But Senator Hatfield wanted to plant a tree that doesn't fit the Olmsted plan for the landscaping of the Capitol. And the problem is that the Olmsteds, which had designed Central Park and Forest Park in Oregon and much of the D.C. landscaping here, the Capitol grounds, they had in mind broadleaf trees, not the type of tree that Senator Hatfield wanted to plant. And what did he want to plant? Very interesting story here, because in the Pacific Northwest, of course, Oregon's part of the Pacific Northwest, there used to grow millions and millions of a cousin of the grand sequoia and the coastal redwood. And this cousin was different in that it lost its needles during the winter. And it went extinct. It was outcompeted by the cedars and the Douglas firs and the regular redwoods and so on and so forth. It went extinct, but it's fossils everywhere in the Northwest. Now, how could Senator Hatfield plant this tree when it was extinct for millions of years in North America? He could plant it because in the late 1940s, a small grove was found in China of this particular tree, the only place on the planet it still existed. So he'd arranged to get one of these trees, going to plant it there. And at that moment, as they were getting ready to plant, his team saw Senator Kennedy's team and said, Senator Kennedy, you should come out and join Senator Hatfield. And they were out on the mall, not the mall, but this walkway between here and Russell. And Senator Kennedy participated in the ceremony. He said, in honor of the work we're doing together, this bipartisan work on nuclear weapons, this should be known as the peace tree. And they were working on the zero option, or the nuclear freeze movement. Let's not grow anymore, add any more nuclear weapons to the world, already dangerous enough. And they did a lot of work on nuclear weapons. And I must say I was reminded of it when I came here, and John Kerry and Dick Lugar, a Republican and a Democrat, were working on the New START together, and we considered that treaty here on the floor of the Senate. But it became much more difficult now than then to have this sort of bipartisan work. At any rate, please do take a walk if you're here in D.C. and on the grounds of the Capitol, and take a look at that peace tree. That peace tree is just on the verge of becoming the tallest tree on the grounds. Planted in 1985, so it's now 32 years old. And let's hope that as it becomes the tallest tree, it'll have kind of a biblical influence and bring more peace to a world in desperate need of it. But we need more of that peace tree influence here in this chamber. That influence is sorely lacking. The type of cooperation between Democrats and Republicans that existed doesn't exist today, and we are here at this very moment on a tragic course to destroy the centuries-old tradition of a 60-vote majority, bipartisan majority, to proceed to approve a nominee to the Supreme Court. Both that tradition ensures presidents don't nominate from the extremes, and it ensures, hopefully, that the folks who serve will serve the Constitution, the We the People Constitution, not some ideological extreme to the right or to the left. So I want to go back to the core premises of why I'm here tonight talking to the chamber, sharing these thoughts with all those who are watching the chamber. And that is, we must recapture the type of cooperation and bipartisanship that made this chamber able to address the problems facing America. Mahatma Gandhi said if you simply operate by the premise of an eye for an eye, the whole world is blind. Well, if we operate on the premise of the Senate that we are never going to work together to solve problems because we are of different parties or a different party than the president, and we want to make sure the president doesn't get any credit for having helped improve a situation, then all of us suffer from the broken existing policies, the dysfunction of the existing policies, the poison of the super partisanship. So let's go back to the basic premises on which we need to address. The three premises. The first is that this seat is a stolen seat. And can you put back up the chart with the 9 justices? Here's the story in a nutshell. 16 times in our history, there was an open seat during an election year. 15 times the Senate acted. 12 of those times they confirmed the justice, and 3 of those they rejected the justice. But the point is, 15 out of 15 times before Antonin Scalia died and Merrick Garland was nominated by President Obama, the Senate acted. Here's 9 of those. These are the nominations that occurred, like Merrick Garland, in which the vacancy and the nomination occurred before the election. So they're most similar to the situation of Merrick Garland. And then there were another 7 under more difficult circumstances where the nomination did not occur until after the election, and the Senate had very little time in which to vet and make a decision. But they did make a decision, each and every case, until last year, when the majority said, we will not consider the president's nominee. We will not hold a hearing. We will not hold a vote. We will discourage folks from even talking to him. We will not exercise our advice and consent responsibility. That's the first big issue. The second big issue is that the nominee himself is from the extreme right. Do you have the camel chart? Can you send for it? There is a chart that shows, and we don't have it with us, maybe we'll have it later tonight. It is a chart that shows the distribution of decisions. And it has basically 2 curves with a big, kind of bell curves with a big gap in between. So it goes up, it comes down, it goes up and it comes down. And it reflects the ideological division of the court from decisions they have made. And on this chart, the folks analyzing these decisions said, where would Merrick Garland be? Would he be in the we the people bell curve of decision making? Would he be in the we the privileged and powerful bell curve? And they found not only would he be in the we the powerful bell curve, but his position on the curve would be to the far right of the peak of the curve. And as I mentioned the analysis earlier by the Washington Post, this is an individual who was rated by the professional analysts as being more conservative than anyone who serves on the court. And I went through a series of cases, and I'll be going through them again as the night wears on, in which he twisted the law to find for the powerful over the individual time and time and time again. Someone who is way outside the judicial mainstream and who twists the law to find for the powerful over the people doesn't belong in the Supreme Court of America. So that's the second big problem. The third big problem is that the president's team is under investigation for collaborating with the Russians interfering in our November general election. This is a very serious question. There is a very dark cloud over the legitimacy of the election and therefore the legitimacy of this president. If President Trump worked to conspire with the Russians, or his team conspired with the Russians at his direction or his knowledge, that is traitorous conduct, because the Russians attacked the fundamental institutions of our country, trying to delegitimize and change the outcome of our election, and conspiring with a foreign power to attack the foundation of our democratic republic. That is traitorous conduct. We have to get to the bottom of it, and we shouldn't be considering on this floor a nominee under that set of circumstances. Let's complete the investigation, find out what went on, and if the cloud clears, then we can proceed. So those are the three substantial issues for why we should not be here considering this nominee. The stories I was sharing with you about how I first came to the Senate as an intern for Senator Hatfield, and then came back to Capitol Hill working for a think tank sponsored by Congress, the Congressional Budget Office. And my responsibility was to analyze the impacts of various potential strategies in the development and deployment of our strategic triad, our nuclear triad. We have air-delivered and ballistic missile delivered, land-based ballistic missile delivered weapons. We have submarine-launched weapons. That's the triad. That was my job, to consider the implications of the paths that we might go on. What were the budgetary implications? What were the performance implications? What was the implications for deterrence, or the circumstances that might trigger a nuclear war? So I was back here on Capitol Hill in that capacity. What I saw was a Senate so fundamentally different than the one we have today. I was reminded of this when, back in 2013, I was working to bring a bill to the floor called the Employment Non-Discrimination Act. Now, this is an act that Senator Ted Kennedy had sponsored, and if I recall right, first sponsored in 1994. And then 2 years later, I believe it was in 1996, it was considered on the floor of the Senate. And it lost by one vote. It lost 50-49. And the senator who was missing is believed to would have voted for it. And the vice president, breaking a tie, would have voted for it. But people felt, well, it'll be back up before the Senate soon enough. Now, a point here is that the vote was a simple majority in that setting, and the filibuster was reserved for very rare circumstances. Now, this happened to be a bill related to ending discrimination for our LGBT community in employment, and anything involving a social, what some may construe as a social issue, is one that many people have politicized greatly. And this was simply an issue of fairness in employment. But nobody required a supermajority to close debate. They reserved the supermajority for profound principles, and it was exercised very rarely. So since this body could function because it was primarily a simple majority organization. And when I was covering the Tax Act of 1976, the issues on these amendments that came up one after another, it seemed like every hour, simple majority votes, a lot of bipartisan cooperation. We become so polarized. We become so divided. And this nomination and this hearing right now are going to reverberate through the decades to come as the lowest point, the biggest failure of this institution. Now, we do have the power to prevent that from happening, because we haven't yet voted on closing debate, and yet we have just a short period of time to set this nomination aside. Set it aside. Tell the president you need to heal this institution and the court by nominating Merrick Garland. Set it aside because the nominee, Neil Gorsuch, is from the radical right-wing fringe, out of the tradition of having mainstream justices. Set it aside because there's an enormous cloud over President Trump as to whether he is a legitimate president, given the investigations into the conspiracy with Russia. For all those reasons, set it aside. Also set it aside because never before has a majority leader tried to shut down this debate with a petition to close debate on the very first day. Now, it takes 2 days for that petition to ripen. There are folks who have said, almost never is a Supreme Court nominee filibustered. Well, it gets a little confusing because what does filibuster mean? Does it mean deliberation at length? In that case, we've had a lot of nominees filibustered because they've been deliberated at length. Does it mean that we vote on a petition to close debate? Well, that really changes the analysis because we've rarely had a petition to close debate on a Supreme Court nominee. And we've never had a petition to close debate filed on the first day of the debate because of the mutual respect that all the voices would be heard, and if someone was controversial enough for people want to talk for days and days and days and days, this body heard them out, and the American people heard that conversation and responded to it, and trends developed, and eventually people said, you know what, no, this person really is suitable, and they were confirmed. Sometimes they were withdrawn by president, but the point is, in rare cases, was a petition filed to close debate. And yet here we have it. First time in U.S. history, just happened a couple hours ago. Shut down the debate as fast as you can. It's the opposite of a deliberative body. When I was back here as an intern, we had that age-old saying about the Senate, the world's greatest deliberative body. And I saw that body. I saw people here on the floor talking to each other, listening to each other, holding a debate, voting on an amendment, and immediately going to the next amendment. I remember on one occasion, I mentioned that once an amendment was done, there wasn't another one negotiated between the Democrats and the Republicans, so there were long periods of silence the way we operate now. No, it was the next person recognized by the chair. And the chair heard a lot of people at once, probably worked to send one amendment to the left side of the chamber and one to the right side of the chamber, one to a senior member, maybe one to a more junior member. But eventually, because of the expeditious consideration, everyone got to have their idea considered and pretty much voted on by a simple majority. But how different that is from what's happening right now at this moment in this chamber when we are at the very peak of pointed partisanship coming from my colleagues across the aisle. They have stolen a seat, first time in U.S. history. They have proceeded to put it on the floor and, for the first time in history, filed immediately a petition to close debate. Every 5-4 vote from here on until, who knows, our children's children will be looked at and people will ask, is this a decision because of the stolen seat? Would this have been a we the people decision rather than a we the powerful if not for that stolen seat? That is a huge erosion of the legitimacy of the court. Do members of this chamber really want to do that kind of profound damage? Well, they will do that profound damage if the current direction continues over the next couple days. And that's a place that I don't want us to be. And therefore, and kind of my own personal protest of where we have come to, my own request that we change direction, I plan to keep speaking for quite a while longer, as long as I'm able. And that will hopefully be at least a couple more hours. So I'm going to go into more depth about these issues that I've laid out. And I'm going to start by going through each piece in a lot more detail. So where did we start? Well, this journey began with Judge Scalia's death on February 13th, a little over a year ago. And then it was a month later that the president fulfilled his responsibility under the Constitution and nominated Merrick Garland. There were still 10 months left in the administration at that time. Now, earlier, I heard the majority leader say no one's ever filibustered a Supreme Court nominee. Well, that's not quite right. There's been some filibusters, and more or less, depending on how you define it. But what happened last year was a 293-day filibuster by my Republican colleagues of Merrick Garland. Not just an ordinary filibuster, but a special sort of failure to exercise their constitutional responsibility of advice and consent. The first time in our history that a nominee was not acted on when the nominee was being considered for a seat that came open in election year. You know, there are a few of my colleagues who like to say, well, the former vice president, Joe Biden, he gave a speech, and he said, if a seat comes open, it was theoretical because there wasn't an open seat, if a seat comes open in the summer of an election year, maybe we shouldn't consider it until the intensity of the campaign has passed, meaning after the election. Well, we saw earlier when I put up the chart, and I'll put it up again, that there were seats that opened up before an election, and then the president chose, that's the seat where they opened before the election and they came up afterwards, nominated afterwards. So in these seats here, these 4 seats, the vacancy was before the election in August. In May and October, the nomination didn't come until after the November election, in December and February, December and January. And yet the Senate acted in those situations. So no matter how you slice it, 15 times there's been an open seat, some occurring after the election, and yet the Senate acted on the nominees. Some occurring before the election, but the nomination didn't occur until after the election, and the Senate acted as it did in these cases. And then another 9 cases where the nomination opened up before the election. So Biden made this point, simple point, that if the seat opens in the heat of the summer before the November election, maybe it would make sense to hold off consideration of the nominee until after the election. That's completely consistent with our history. My colleagues tried to twist it into something else as an argument that you shouldn't consider a nominee during an election year. And of course, that wasn't what Biden said at all. Not even close. But let me tell you, when you have to try to find one sentence from 20 years ago from one of the people who have served in the Senate, and that's the only evidence you can find to back up your case, you're not just on thin ice. You've fallen through the ice into the pond. Your argument is that weak and that terrible. And so whenever you hear my colleagues say, well, didn't the vice president, when he was a senator, suggest a theory that we shouldn't consider a nominee during the heat of the campaign right before an election? Yes. He said it should wait until after the heat of the campaign. And it was one sentence 20 years ago from one senator. If your argument is that weak, please try to find some better argument to make, because we're not here considering something of small importance. We're here considering an issue that has profound consequences for the integrity of the Senate, because it's the first time a seat has been stolen in U.S. history, a Supreme Court seat's been stolen, and huge impact on the integrity of the Supreme Court, because the Supreme Court, this is a court-packing scheme. And if the court is packed, it delegitimizes their decisions. So let's not pack the court. That's why I'm here speaking tonight. On February 13th, the very same day that Merrick Garland's nomination occurred, but that Antonin Scalia passed away, that very same day, Majority Leader came to the floor and released a statement saying essentially, we intend to steal this seat. And here's what he said. Majority Leader McConnell, he said, quote, "The American people should have a voice in the selection of their next Supreme Court justice. Therefore, we won't fill this vacancy, or no. Therefore, this vacancy should not be filled until after we have a new president." He reiterated opposition to any Obama nominee the day that President Obama fulfilled his constitutional responsibility by standing in the Rose Garden and nominating Merrick Garland. And when our Majority Leader reiterated his opposition, what did he quote? That the one passage taken out of context from Biden's speech 20 years ago. That was the foundation on which he based a proposition to forego our responsibility as a Senate to provide advice and consent under the Constitution. One sentence out of context, turning the meeting on its head from a former senator from 20 years ago. That's how weak the case was that the Majority Leader presented for failing to do our constitutional responsibility. That was how weak the case was that he presented for stealing a Supreme Court seat in a court-packing scheme. Well, he said, give the people a voice. Well, the American people voted overwhelmingly for Hillary Clinton. She won by more than 3 million votes. She would have won by a lot more if it wasn't for voter suppression. No, we have one party that generally believes in voter empowerment, that the foundation is we the people, and that our part of citizenship is to vote. And we have one party that has resorted to trying to prevent people from voting. Voter suppression, gerrymandering, changing the shapes of districts to deprive people of a voice here in Congress, changing the dates changing the dates in which early voting can occur so people have less of an opportunity to vote, changing the location of precincts where your voting takes place. Some of the voter suppression tactics involve things that are just misinformation, false information, telling people the vote's already occurred, or the location's been moved when it hasn't, or the votes are going to close earlier than they actually are scheduled to close, or a whole host of things. But the Majority Leader said, give the people a voice. Well, the people voted overwhelmingly for Hillary Clinton. So it would follow that the Majority Leader would come to this floor and say, people voted overwhelmingly by 3 million votes, and it would have been a lot more, so we will now consider Merrick Garland because he was the nominee from a Democratic a president, the seat we stole, the people have spoken, the majority have said, we don't want the Republican, we want the Democrat, so we'll go ahead and hear the Democratic nominee, and we'll vet him and vote on him, Merrick Garland. But funny thing, that didn't happen, because the goal wasn't to give people a voice. The goal was to steal the seat and deliver it to a Republican president who would nominate someone from the extreme right and pack the court, undermining we the people in favor of we the powerful and the privileged. So the Democrats didn't politicize the court. The Republicans politicized the court. And the American people did have a voice in Garland's nomination. They had the voice by voting twice for President Obama. And throughout our entire history, the Senate has considered the nominee from the president in power when the vacancy occurs, even when it's an election year. Because that's what the Constitution tells us to do. Not to steal the seat, not to pack the court. This politicization, this gamesmanship, this hypocrisy is so extreme and so dangerous. I heard that some of my colleagues were asked if they want their election year rule to apply to President Trump, that he couldn't fill a seat that comes open in the fourth year of his presidency, because that's the principle they advocated for last year. And their answer was, no, because there was no principle to the position. It was a warfare tactic of partisanship to pack the court. It was a end justifies the means, even if the means violates the core premise of the Constitution and does deep damage to the Senate and does deep damage to the court. Just this past Sunday, while speaking to Chuck Todd on Meet the Press, the majority leader began to walk back his past statements that Supreme Court vacancies shouldn't be filled in an election year. Todd asked, quote, "Should that be the policy going forward? Are you prepared to pass a resolution that says in election year any Supreme Court vacancy won't be filled, and let it be a sense of the Senate resolution that says no Supreme Court nominations will be considered in an even-numbered year?" And the majority responded, "That's an absurd question." Why is it an absurd question, given that's the principle that election year nominations should go to the next president? I'll tell you why it's absurd. It's absurd because it's contrary to the Constitution. And so the argument, Mitch McConnell, my majority leader, the majority leader of the Senate here, the top person in charge, he's right when it said it was absurd, because of course we should not abandon our constitutional responsibilities. It's an absurd argument to make today, and it's an absurd argument when he made it last year. And if it was only absurd and not deeply damaging, then we could all perhaps not be so deeply, deeply concerned about this situation. Merrick Garland's record. Judge Garland had more federal judiciary experience than any Supreme Court nominee in our nation's history. So the nominee put forward by President Obama had more federal judiciary experience than any nominee in our nation's history. Summa cum laude and valedictorian from Harvard College. After graduating, he clerked for Judge Henry J. Friendly in the U.S. Court of Appeals for the Second Circuit. He clerked for Justice William Brennan, Jr., a United States Supreme Court justice. He was in private practice at Arnold & Porter, focusing on litigation and pro bono representation of disadvantaged Americans. He left his partnership for a low-level prosecutor position in the administration of George H.W. Bush. In 1993, Merrick Garland went to the Justice Department as Deputy Assistant Attorney General in the Criminal Division. And that's where he oversaw prosecutions in the Oklahoma City bombing, helping bring Timothy McVeigh to justice. He helped oversee prosecutions in the case against Ted Kaczynski, the Unabomber, and the Atlanta Olympics bombing committed by Eric Robert Rudolph that killed one person and injured 111. He made a name for himself in these cases by being a strictly by-the-book prosecutor. He insisted on obtaining subpoenas even when companies volunteered to hand over evidence. He insisted on keeping victims and relatives informed as the cases developed. He served for 19 years on the D.C. Circuit Court. Well, that's a lot of experience. And all of that happened before he was nominated by President Bill Clinton in 1995 for the D.C. Circuit Court. He received a confirmation hearing in the Senate Judiciary Committee in December of that year. But Republicans did not schedule a floor vote on his confirmation because of a dispute over whether to fill the seat. So President Clinton renominated Merrick Garland for the Circuit Court on January 7th, 1997, and he was confirmed on the Senate floor by a vote of 76 to 23 that year in March. At the time of the consideration of Merrick Garland on the floor, my colleague from Utah, Senator Hatch, had very flattering things to say about Merrick Garland. He said, quote, "To my knowledge, no one, absolutely no one, disputes the following." This is Senator Hatch speaking. "Merrick B. Garland is highly qualified to sit on the D.C. Circuit Court. His intelligence and his scholarship cannot be questioned." And he continued, he said, "I do not think there is a legitimate argument against Mr. Garland's nomination, and I hope our colleagues will vote to confirm him today." And then he said, "In all honesty, I would like to see one person come to this floor and say one reason why Merrick Garland does not deserve this position." And the senator went on to suggest that his colleagues who were blocking the confirmation vote were trying to obstruct his confirmation and were, quote, "playing politics with judges." I so respect the statement that my colleague from Utah made in 1995, admonishing his colleagues to quit playing politics with judges. But what has happened between 1995 and 2017 over these last 22 years? A huge amplification of playing politics, to the point that when Merrick Garland came back before this body, only a couple Republicans were willing to stand up and say, "Let's quit playing politics." And they were quickly silenced. During his 2005 confirmation hearing, Chief Justice John Roberts remarked about serving on the Circuit Court with Merrick Garland, quote, "Anytime Judge Garland disagrees, you know you're in a difficult area." So here is the Chief Justice, considered one of the conservatives on the court, who's saying, if you disagree with Merrick Garland, you're in a difficult area. You have to go and figure out why would you disagree, because he's so good at working his way through the law and coming to a position of calling the balls and strikes. That's the type of respect there was for Merrick Garland. And this respect and admiration continued right up to his official nomination. On March 11, 2016, 5 days before his nomination, my senator colleague, my colleague from Utah, told a reporter that if President Obama named Judge Garland, quote, who is a fine man, unquote, to fill Scalia's seat, he would be a, quote, consensus nominee, unquote, and that there would be no question of him receiving a bipartisan confirmation. 5 days before the president nominated Merrick Garland, the president recognized that the Senate was controlled by the Republican majority. He consulted on both sides of the aisle. He chose a senator admired on both, not a senator, but a nominee admired on both sides of the aisle. Standing in the Rose Garden on March 16th of last year, President Obama officially nominated Judge Garland to replace the late Justice Antonin Scalia, and President Obama called Merrick Garland the right man for the job. He deserves to be confirmed. His nomination had endorsements from a broad range of organizations and individuals. The American Bar Association, the Hispanic National Bar Association, 8 former Solicitors General, Neil Katyal, Gregory Garr, Paul Clement, Theodore Olson, Seth Waxman, Walter Dellinger, Drew Days, Kenneth Starr. You recognize some of those names. Some come from the right side of the spectrum, some from the left. The point was 8 former Solicitor Generals. Kenneth Starr, 1989 through 1993, and Drew Days, who followed him, and Dellinger, who followed Days, and Waxman, who followed Dellinger, Olson, who served from 01 through 04, and Clement, who followed Olson, and Garr, who followed Clement, and then Neil Katyal, who served in 2010-2011. Endorsement from the American Bar Association Standing Committee on the Federal Judiciary rated him well qualified as a Supreme Court nominee, the highest rating they could give. And their evaluation of his record stated that Judge Garland, quote, meets the very highest standards of integrity, professional competence, and judicial temperament. So there you have our President Obama, last year, consulting in a bipartisan fashion, choosing a nominee who'd been highly complimented by senators on both sides of the aisle, seeking to find someone straight down the judicial mainstream. And what was the response of the majority leader? Majority leader of our body, our assembly here. His response was, we're going to steal this seat. Doesn't matter that this nominee is highly qualified. It doesn't matter that Democrat and Republican senators have complimented him highly and have high respect for him. It doesn't matter that the Chief Justice has enormous respect for his judicial thinking. We are going to steal this seat in hopes of being able to pack the court. That's what happened later in the day after Merrick Garland was nominated. The Senate has always functioned by cooperation, big element of tradition thrown in. A defining feature of the Senate is a commitment to the traditions of fair play and allow us to continue functioning to solve America's problem in politicized circumstances. This is enormously important to the success of this chamber. I had heard when I was running for the Senate in 2007 and 2008, I had heard that something terrible had happened with this chamber in the years that I had been back in Oregon, and that a group had decided they would use this chamber as a weapon against any Democratic president rather than as a forum to solve America's problems. And I didn't believe it. I didn't believe that the Senate I saw as an intern in 1976, that I saw when I was volunteering for organizations and working here in D.C., washing dishes and waiting tables in 1977, that the Senate I saw when I was a presidential fellow with a Republican Defense Secretary, Secretary Weinberger, that the Senate that I saw when I worked for Congress in a think tank on strategic nuclear weapon policy for the Congressional Budget Office, I couldn't believe that a group of senators had decided to use this chamber as a weapon against the executive branch, if the executive branch happened to be from the other party. I didn't believe it. I dismissed the commentary I was hearing about what was occurring in this chamber. And then I arrived in 2009, and I quickly saw that I was wrong, that the stories that this chamber had been taken over by an urge to use it as a weapon against Democratic presidents had in fact true. And we all kind of were nearly knocked over when the majority leader announced that his goal was to make sure, his top goal, his determining vision was to use this chamber to prevent President Obama from being reelected. And we're sitting here going, let's work together on health care policy. Let's work together to make a fairer tax system. Let's work together to develop the infrastructure that is so needed, because the infrastructure that our parents built is wearing out. Let's work to develop that infrastructure because we have new demands of a different economy. And we need better bridges and better rail and better ports and better electric transmission lines. And we certainly need better broadband, or at least broadband of some kind as a starting point in rural America. Those are the challenges we face. Let's work together. And then I watched as a key issue was turned into a political weapon against the president rather than working to solve problems here in America. And that issue was health care. In April 2009, I was handed a brief written by Frank Luntz, who was a strategist for the Republican team. And that brief said, whatever ideas that the Democrats work to pursue on health care, here's our strategy. Don't cooperate and call it a government takeover. Whatever they do. And I came here down to the floor, and I gave a floor speech, 2009. I waved around the Frank Luntz memo, and I said, this is what's wrong with America. We have millions and millions of people without access to health care in America, and instead of working together, the Republican strategist is saying, whatever ideas to improve the health care system they come up with, oppose them and call it a government takeover. Well, the Democrats said you need bipartisan cooperation to get a health care bill through here. And so they held 5 weeks of hearings in the HELP Committee, Health, Education, Labor, and Pensions Committee. And I was assigned to that committee. Senator Ted Kennedy had assigned me to be on that committee in partnership with Majority Leader Harry Reid. I was so happy to be on that committee. And I saw for 5 weeks around a square table, idea after idea presented as amendments, discussed, debated, and voted on. Approximately 150 Republican amendments were adopted. Can you imagine a committee adopting today, under the control of the Senate, 150 Democratic amendments on a major bill? Adopting, not just considering. And the Democrats went through every title with the television there. All of America was watching for 5 weeks. And that was just for the Health Committee. And then there was a whole nother process with the Finance Committee, in which Senator Baucus led a group with, I believe, Senator Grassley, if I'm not mistaken, and they had 3 Democrats and 3 Republicans, and they worked on the finance side, trying to come to a bipartisan conclusion. But eventually, Frank Lunt's vision won out. Whatever is suggested, oppose it and call it a government takeover. That will do the most damage to the president. That was the strategy. And so the Democrats said, well, it looks like we're going to have to take the Republican health care plan. What was the Republican health care plan? The Republican health care plan was to use a marketplace in which private companies would offer their insurance. You could compare the insurance, one policy to the other, to find out which one best suited your family. And then you could get, based on income, tax credits to be able to afford to acquire that insurance policy, so that essentially we would have a pathway to health care for every American citizen, for the millions and millions of people who didn't have that pathway. That was the Republican plan. It came out of the American Enterprise Institute as the marketplace solution for health care. It wasn't a public option. It wasn't, let's lower the age of Medicare. It wasn't single buyer. It was the Republican marketplace plan. It was already one that had been tested by a Republican governor in Massachusetts. It was known as Romney Care. So the Republican think tank plan, the Republican governor tested plan, and the Democrats said, okay, let's go that way. We think there's better pathways, but we'll go with that because we need to be able to bring this chamber together. But my colleagues across the aisle, under this vision of using the Senate as a weapon against a Democratic president, decided that they were going to oppose it, just like Frank Luntz laid out in those first few months of 2009. We see that same profound partisanship in this first ever theft of a Supreme Court seat. We see that same profound partisanship in the strategy behind that theft, which is to pack the court. We see that same profound strategy in the action that happened a couple hours ago, that was the first time in U.S. history that a motion to close debate was filed on the first day of a Senate debate. So turn the clock back to those first 13 states and 26 senators. They were trying to figure out how the Senate would operate. They weren't really planning on it being a public forum, but they did have this sense that it would be wrong to close debate before every senator had shared from their experience. And so they had a rule in their initial rules of the Senate. They had a rule to close debate. And they never used it. They never used it, as far as we know, not once, because they wanted to give everyone the chance to be heard. Of course, the Senate was only a quarter the size, 26 senators instead of 100 senators. When they rewrote the rules of the Senate, they said, we don't need to have a rule for closing debate by simple majority, call the question if you will. And we don't have to have it because we're going to hear everybody out before we vote. Well, so that kind of launched that tradition of hearing each other out. And later, when the Senate restored a rule in which a supermajority closed debate, it took a supermajority. And at another point, the Senate said, we need to have a little smaller of a supermajority. The reason that what triggered going back to having a strategy for closing debate was in World War I, and I know that historians will correct me if I have this wrong, but in World War I, the president wanted to put military defenses onto some of the commercial ships to fend off the threat from the Germans. And there were senators who said, this will draw us into the war. We're not in the war yet. This will draw us into the war by weaponizing our commercial ships. And they proceeded, there was a date set for the Senate to adjourn. They proceeded to keep talking until that time arrived, so that the Senate could not act to pass that law that the vast majority of the Senate thought was appropriate. And so they said, well, we can't have just a small group. They being the tail that wags the dog, that denies the ability of us to make decisions. So we'll have to have a strategy for closing debate. And so they established that strategy. But the general principle behind it was, most of the time you hear people out here in the Senate rather than closing debate. But what we saw tonight, first time in U.S. history, cloture petition filed on the very first day. James Madison, speaking to the Constitutional Convention, remarked that the Senate was a necessary fence, he called it, to protect the people from the transient impressions into which they themselves might be led. It was a reason for the longer terms for the Senate. And you have 2 years in the House, you have 6 years in the Senate. The Senate rotates, so a third are elected every 2 years for those 6-year terms. There's a saying attributed to President Washington that, as far as we know, he never said, but still it was clever enough that it's reverberated on down through the centuries, saying that the Senate would be the cooling saucer. So that if you had your tea, it was too hot, you pour it into the cooling saucer until it's just right. You don't act impulsively because you have these 6-year longer terms and you have a smaller body that can ponder the issues more carefully. So there's the Senate intended to be the cooling saucer. But what do we have right now? We have the stove turned up to the highest possible temperature. There's no stepping back from this course of undermining the integrity of the Senate and the integrity of the court. It's full steam ahead. It's file the petition on the first day of debate so we can close this debate and have this vote done by Friday, the majority leader has said. Vote on Thursday. Somehow we're going to maybe change the rules and vote on Friday if there are not enough votes to close debate. Back in 2013, there was an enormous blockade using the advice and consent power to obstruct both executive branch nominees and judicial nominees. This enormous blockade, my colleagues across the aisle were using it as a weapon against the judiciary and executive branch. Now, when the conversation occurred back among the founders, they said advice and consent power won't have to be used very often to turn down a presidential nominee, because just the very fact that the Senate can serve as a check on a presidential nomination will cause a president to make wise appointments. They'd actually wrestled with how to construct this situation. How do you construct this check and balance? So some had said, you know, if in the executive branch, why don't we have the president head it, but have the positions filled by Congress? And others said, you know, that's not such a good idea, because one senator's friend will be nominated for this position in exchange for another senator's friend nominated for that position, and the people will never really know who's where, why. There's no accountability. That's what it came down to. They said, so we will have a single person, the president, nominate for the executive branch. And plus, that way, the president can nominate people to help fulfill the vision that the president campaigned on, which makes a lot of sense. The people didn't just elect a name, they elected a vision for the country. And the person responsible for helping to implement that, the executive branch, the president, should have a team that can go forward with that vision. So then the crafters of the Constitution said, but what if the president goes off track and starts nominating people who don't actually have the skills to fill the positions to which they're nominated? Or what if the president nominates people because they have done some favor for the president in the past, so that there's a conflict of interest? Or what if the president nominates someone of poor character? Shouldn't there be a way to put a check on a deeply misguided nominations? And the founders said, yes, we will create an advice and consent power for the U.S. Senate to be a check on misguided nominations. So here we are, looking at that original philosophy of the Senate and a responsibility to stop misguided nominations through advice and consent. And we have two profound betrayals of that responsibility last year and this year. The betrayal last year was the Senate refused to exercise its responsibility at all. It stole the seat. It sought to pack the court. And now we have a deeply misguided nomination before us, an individual who is from the extraordinary right, not from the mainstream, who has twisted the law time and time again to find for the powerful and the privileged over we the people. And yet that nomination is here on the floor. Not a single vote in the Judiciary Committee from across the aisle. This chart reflects the distribution of federal judge ideology. If we had been putting up this chart decades ago, you would have probably seen a single bell curve. There'd be folks on the right and folks on the left. But now we have the Twin Peaks chart of judicial decision-making. And so the decisions are falling more and more into a we, the people, camp that says, let's fulfill the vision of our Constitution, and a we, the powerful camp that says, let's turn the Constitution upside down and run this country by and for the powerful. And where does this nominee fall? Not into the we, the people vision of our Constitution, but not even within the left side of that we the powerful twin peak, but to the right side of it. That's where we're at. The supermajority to close debate, commonly referred to as the filibuster, is a power that we have sustained in order to have nominees who are not from the ideological extremes. But now we have one. We have one who, when a trucker was protected by the law because of his personal safety, and he was freezing in sub-zero temperature and had to go get warm and come back, and the law protected him from getting fired, and he got fired, and the court said absolutely you can't fire someone for protecting their safety or others, and Judge Gorsuch found a way to turn that on its head. Or when we wrote a law to say you have to provide an education to disabled children, Judge Gorsuch said babysitting is fine, as long as there is basically, not the exact words, kind of mere fringe of advancement, something that was essentially equivalent to babysitting. And the Supreme Court, all 8 justices occupying both of those peaks, all said that is absurd, and they overturned Judge Gorsuch 8-0. So we have this role in our founders of being the cooling saucer. We have this role of being a check on the abuse of or misguided presidential nominations. And we failed it last year by not doing our job, and we failed it this year by considering anyone other than Merrick Garland. And we certainly fail it in the context of considering the possibility of closing debate. That's the conversation that the majority leader has been invested in, that if this judge is so extreme as to not to get the 60 votes to close debate, we'll change the rules. Well, how about we change the nominee? How about we save the integrity of the Senate? How about we save the integrity of the Supreme Court? Change the nominee. Ideally, put Merrick Garland up, because that way we solve the problem of the stolen seat, this enormous court-packing plan that is unfolding right before our eyes. And if the schedule on which the majority leader has said he wants to complete this court packing occurs, by Friday it will be too late. We will have done the damage. George Washington shared the view of the Senate's role. The story goes that Thomas Jefferson returned from France to take on his duties as our first Secretary of State, and he was having breakfast with President Washington and called for the account. He called the president to account for having supported an unnecessary legislative chamber, the Senate. They're having this conversation, and that's when that conversation came up. In this, we believe it to be apocryphal, but still, the response, as written down at some later point in time, was, Washington asked of Jefferson, "Why did you just now pour that coffee into your saucer before drinking?" To which Jefferson responded, "To cool it. My throat is not made of brass." "Even so," said Washington, "we pour our legislation into the senatorial saucer to cool it." Is there a way that we can avoid what is unfolding now, this tragic miscarriage of the Senate's responsibilities? Whether that conversation took place, as I mentioned, is not actually known, but the fact that the story is still here means that it had some power behind it, whether it took place or not. And that was that for 200 years and counting, the government has counted on the Senate to pause, to not give
All right, folks. So it looks like something happened to the feed in the Senate floor. So we'll be shutting down for tonight. We'll start again tomorrow at 6 a.m. 6 a.m. Pacific, 9 a.m. Eastern here at Golden State Times. And I hope that you guys join us. This guy's been talking for hours, and he's just going to continue talking if it ever comes back. But yeah, folks, thank you very much again for joining us. If you are new to our community, hit that subscribe button. Also, smash that thumbs up button, not for this guy that was talking, but for Golden State Times, if you guys support us and all that stuff. So, again, thank you very much for joining us. Thank you very much for all your support today. And I hope that you guys join us tomorrow, bright and early, again, 6 a.m. Pacific, 9 a.m. Eastern. I am Gent, and I'll see you soon. Thank you very much, Louis67. I hope I said that right. For the super chat. But yeah, folks, have a good night.